Number one.
May I please, ma'am?
Yes.
My lord, in this case, my lord, here, my lord, the forest department, my lord, is implemented later on during the writ appeal stage only, my lord. Therefore, this forest department has filed the affidavit in opposition. I have filed the reply, my lord. Today itself, my lord, I have served the copy today. So I think they may need to go through
Yes,
it,
Your
and
Lordship.
matter can be released after 2 weeks, my lord, for hearing.
1 week, Your Lordship.
Next week, my lord, I have some engagement, my lord. And after 1 week, my lord.
Heard 3 hours sooner learned counsel for the appellant as well as Ms. Learned. Your forest department sending counsel?
No, Your Lordship.
State
I'm
counsel.
appearing for 1 and 2, Your Lordship. CEO as well as Forest Department.
For respond numbers 1 and 2.
1 and 2.
1 and 2. Sri Sonar has informed that the pleadings has informed that the forest department was subsequently implemented at the stage of the writ appeal and pleadings have been exchanged recently.
Today itself, Your Lordship, this morning.
My affidavit replied this morning, I gave, my lord. And for court, my lord, it's in the process.
Implemented subsequently, and the process of exchange of affidavit would be done during the course of the day. He accordingly prays for some time. As paid for list after 2 weeks,
Right.
along with the affidavit that may be filed, that may be exchanged in the meantime.
Congratulations.
No interim order, Mr. Sonar?
No, it will.
My lord, and item number 2, service report to the respondent number 2 is still awaited.
POXO matter. Is it conviction under POXO?
No, not under POXO. 376D, Your Lordship. 376D, Your Lordship.
It has to be routed through your office.
On the earlier occasion, already the same was given to the respective jurisdictional police station, Your Lordship. We have not received the.
Yeah, it was sent through you,
Yes, Your Lordship.
as per Nayak's case.
Yes, Your Lordship.
You get the information concerned,
Yes.
yes, okay. The service report in respect of respondent number 2 has not been received, and the same has been reflected in the office note dated 9/5/2025. Para? Ms. So learned AP, please. Prays for and is granted 2 weeks time to obtain the necessary instructions from the concerned PS
Yes, Your Lordship.
regarding such service. List after 2 weeks.
My lord, in item number 5 also, service report to the respondent number 2 is still awaiting.
Again, same process.
Same case, Your Lordship.
You are appearing, madam,
In item 6, I'm for the victim.
for the
Item
victim.
6. Yes.
5, you need to take the instructions.
Item number, no, Your Lordship. 1 and 7, Your Lordship.
No,
2 and 7.
no, 2 we have already passed orders. And this is item number what?
5, item number 5.
5, what is there in 5?
No, rest of the items, Your Lordship, already the matter, paper book is also prepared, Your Lordship.
In item 5,
My lord,
kindly come to criminal appeal 99. Taso Taruk.
Yes, Your Lordship. Services
that?
awaited, Your Lordship.
Service,
yes, ma'am.
same order.
Same, ma'am.
It is to be routed through the office of the PP. Okay,
Yes.
same order.
Yes, same order, Your Lordship.
Only see, service report has not been received. Office note 9/5/2025, no? Okay, yes. 2 weeks. In five, he was along with six.
Yes,
And
six.
who is appearing in six? Six? Okay. So far as the connected criminal appeal J4 of 2023 is concerned,
Six.
Sri G. Tarak, learned amicus curiae, as well as Miss N. Duncan, learned legal aid counsel for the respondent two are present. Yes, this item number,
Lordship, yes, condonation application, Lordship.
first time,
No, Lordship.
first
Only-
time,
Not first time, Lordship.
okay.
Lordship,
Notice was issued. Yes, what is your,
already condoned, Lordship.
how many days?
346 days.
346 days, okay. Heard. Heard Sri Astapin learned Senegal advocate who has filed this application under section 5 of the limitation Act 1963 for condonation of delay of 346 days in preferring the appeal. The appeal has been preferred against the judgment and order dated so and so passed in so and so. Full stop. Para. In this IA, notice was issued on 19/11/2024, and in the meantime, Sri Panging has entered appearance for the respondent writ petitioners.
Yes.
Full stop. Respondent, at a writ petitioner. Para. Sri Tapin, the learned state council, by drawing the attention of this court to the averments made in paragraph 3 and 4, has submitted that due to reasons which were not within the control of the applicant, the delay has occasioned. Full stop. He has also drawn the attention of this court to the various communications exchanged within the appropriate authorities regarding preferring of the appeal. Full stop. Here, we praise for condoning the delay. Para. Sri Panging, the learned counsel for the respondent, has submitted that the reasons cited are not convincing. Full stop. However, in a similar matter, the delay has been condoned, and therefore he would not have serious objection to the condonation of delay in this appeal, and has submitted that he would rather oppose the appeal on its merits. Para. It is a settled law that while adjudicating a delay condonation petition, a justice-oriented and pragmatic approach is required. Full stop. We are also, the Honorable Supreme Court has also laid down that no extra laxity is to be given only because the appellant is the state which is to be treated at par. Full stop. Para. Be that as it may, and in view of the submissions made, and in the interest of justice, we are that the delay of 346 days in preferring the appeal is liable to be condoned, which we accordingly do. Para. I stands allowed. Para. Let the writ appeal be registered and listed for admission after a week.
Same order may be passing next.
Judgment is the same.
No,
And notice was issued on the same day.
Same,
Okay,
same.
I dispose of.
My lordship, please. This petition
You are in which matter, Mr. Barton?
Huh?
Which matter? Item number
10,
10 for the applicant.
yes. This application is made for alteration, modification of the interim order, which was passed on 29 11/2021. Now, here the applicant are facing hardship due to prolonged delay caused by the appellant and hence filed the eastern application for modification for recall, alteration, modification of order dated on 29/11/2021 and its continuation of interim order dated on 17/5/2023.
Mr. Patil, there are two issues. The order which you are seeking modification is of the years 2021 and 2023. You have filed this application in the year 2025. We are not attributing any fault upon you. We are only saying that instead of concentrating on this IA, we can give you an opportunity to hear, to argue the matter on merits, the appeal itself.
I have given, yes, you honor may see.
Because
entire-
2023
annexure.
and this writ appeal.
They have taken 10 times adjournment. 10 times adjournment.
Okay, we will not grant any adjournment. Yes, you are for whom? Great petitioners.
Yes, writ appeal. Lordship, for a moment, kindly see Lordship, page 143 of the writ appeal.
We are not on those. We have not even entered into the merits of Mr. Patin's argument. We are only saying the writ appeal is of the year 2021. He is seeking modification of an order of 21 as well as 23 by filing this application in the year 2025. We can have the entire writ appeal for final hearing. There should not be any objection. When?
Lordship, after 2 weeks, Lordship, because
Why
Lordship,
not 2 weeks? In the next week.
Lordship, may Lordship. Lordship,
Within this
Justice
week.
Habung has
Within
appeared in
this
the
week,
water
within
in
this
connected matter, Lordship.
Connected
Lordship.
matter?
Yes, Lordship.
Because
Justice Habung, Lordship,
Yes.
kindly see Lordship, page 144,
He cannot take up the matter.
as per my understanding.
No, you must be correct in. Let us see. Yes,
Page 144, Lordship.
144. Mr. Patin,
yes.
my brother cannot take up this
No,
matter.
no, this is a different case. This is different, this is for 543 of 2005. That is different party, but our party is different.
No, if it is connected, if
No,
there is
no,
any difficulty, then
Department is same, but the case is different, completely different. My point is that the promotion has been given beyond the quota. Promotion.
this is a part of the record. I think it should be heard by another bench. This is a part of the records. It's not that he has got something. It's a part of the writ appeal itself. When my brother was a counsel, let it be before another bench. But we'll give you a date after 2 weeks. Okay?
2 weeks and this should not be final and no adjournment.
But you don't take adjournment.
I don't take adjournment.
Yes, what do you say?
Yes, Lordship, after 2 weeks, Lordship.
Okay.
In a particular date.
You will give a date. But we'll go next week. Hopefully. Heard Sri M. Patil, Learned Senior Counsel, assisted by your name? Keta. For the applicants who by means of this application has prayed for alteration, modification of orders dated 29/11/2021 and 17/5/2023 passed in the connected WA 11 of 2021. Full stop. It is submitted that while the aforesaid orders, the judgment dated 26/10/2021 passed in the writ appeal WPC 66 AP of 2023 has been stayed. Full stop. The senior counsel for the applicants has submitted that serious prejudice is being caused to his clients because of the stay order, which requires modification. Para? Also heard your name, huh?
Elbam,
Learned counsel for the
appellant, writ appellant, Lordship.
for the writ appellants who has opposed this application and has also raised the issue of delay in approaching the court for modification of the orders in question. Full stop. Para. after hearing the parties, we are of the that the writ appeal is itself of the year 2021 and the interim orders of which modification is sought for are of the years 2021 and 2023. Full stop. Therefore, instead of considering the IA, the writ appeal itself is required to be heard. Full stop. At this stage, three party in the London Senior Council has submitted that on numerous occasions appeal was adjourned at the instance of the appellant. Full stop. Para. Considering the above, we dispose of this IA by directing that the connected writ appeal number WSNs be listed for hearing on today is 13th. We'll have it on 27th. Okay? 27 June, Tuesday,
27 June.
June, or 27th May, sorry, 27th May.
Yes. I-
Huh? No. 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 Further, as pointed out, comma, the matter may be listed in a bench without one of us within bracket. Huh? Look.
May I seek your lordship indulgence to mention, my lord, item number 12 to my lord, item number 20, my lord, 12 to 20. But these are interconnected matter pertaining to challenging the fact finding committee and land compensation. My lord, if you remember, my lord, in Neelam Obi, your lordship appeared, my lord.
Which one?
In Neelam Obi case, my lord, your lordship appeared, my lord.
Leela, Bobby.
Neelam Obi, which is pending in division bench. They prepare an
So then
appeal.
that case will
It's
not take up.
interconnected, my lord. So
Will not take up.
some other appropriate bench, my lord.
Okay. Item number 12.
12 to 20, my lord.
Pre-NH Nabu, the learned AAG has pointed out that in a connected matter, this court had appeared as a counsel. Full stop. Para, in view of the aforesaid submission, list these matters before any other bench.
Obliged.
12 to
12 to 20, my lord.
all connected.
All connected.
Okay.
Wait, Vijay. Well, the beg to mention item number 29. I have instructions not to place the matter, my lord.
29. Sri D. Panging learned, who's for the other side?
I am appearing, my lord, 1, 2, and 3.
Sri D. Panging learned counsel for the, heard Sri D. Panging learned counsel for the petitioner. Also heard Sri D. K. Sharma, learned counsel appearing for the IOC and its officers. Para. Sri Panging, the learned counsel, has however submitted that he has instructions not to press this writ petition. Para. The effort prayer has not been opposed by Sri Sharma, the learned counsel. Para. In view of the above submission, writ petition is dismissed as not pressed. Interim order was there.
Yes, my lord.
The interim order, no, don't say the interim order, comma, if any, stands vacated. Yes,
My lord, item number 5, my lord, pray for some accommodation, my lord.
5.
Can it be after 2 weeks, my lord? I have informed Mr. Ratan also.
Yes,
I have informed Mr. Ratan.
Mr. Ratan, item 5. After 2 weeks, he is playing for,
Yes,
on by Sri D. Panging, learned counsel for the petitioner. List after 2 weeks, Sri N. Ratan, learned state counsel is present. 2 weeks. Yes.
Progress.
May Lordship, I beg to mention item number 2. Your Lordship, here I'm seeking some time since I have been informed that both the parties are inclined to
Item
settle.
number 22 is of the year 2020. Why are you seeking time in a whole
Your Lordship, I have been informed that both the parties are inclined to settle the matter outside.
Who is for the other side? What do you say?
For the state respondent.
You're for the state. Who is for the private respondent? Who is for the private respondent?
Yes, not capital.
20 matter granting an adjournment is difficult for us. Okay.
Since Your Lordship, since it's a
What is your
purely
name?
J Karbak.
J.
J Karbak.
Karbak. Sri J. Karbak, learned counsel for the petitioner, has submitted that there are talks going on amongst the contesting parties for resolution of the matter outside the court. And therefore he prays for some more time. Para? Also heard Sri so learned. You are for the state?
Yes, Your Lordship.
Learned State Council. Para? After considering, I can't, don't say after, considering that this writ petition is pending since the year 2020, a final opportunity is granted for to the parties to come to an amicable settlement. Full stop. List after 6 weeks. 6 weeks.
Oblige, Your Lordship.
Much obliged.
My Lordship, I beg to mention item number 3, Your Lordship, on
Yes.
behalf of J. Gini, Your Lordship. Today, he is unable to appear, so I am praying for listing this matter tomorrow, Your Lordship.
Tomorrow, okay, no
Tomorrow.
problem.
No.
On a prayer made on behalf of Sri J. Gini, learned counsel for the petitioner. Matter is adjourned to be listed tomorrow.
Oblige.
Okay. Sri Sansu Learned State Council is present. Tomorrow.
Lordship, I mentioned unlisted matter, Your Lordship.
For motion,
No, Your Lordship. For hearing, Your Lordship.
hearing unlisted, how can you move? Matter of which year?
2025,
21,
2025, Your Lordship.
25,
Yes, Your Lordship.
hearing. Hearing or motion?
Actually, Lordship, this IA was fixed on court too last time, Your Lordship, but that Honorable Court instructed me to take steps that day, Your Lordship.
You cannot go for hearing by an unlisted motion. What is the difficult urgency that you cannot wait till tomorrow or day after tomorrow?
Lordship, 23rd of this month, I have this criminal case is pending before JMFC against me, Your Lordship. That trial is going on, Your Lordship.
Today is what? Today is 20, today is 24, you have go, you move this matter day after tomorrow. What is the problem, hurry? Okay? But not for hearing, it will come for orders. Okay? Thursday, give Thursday's date. Change the date, okay?
May I please, Your Honor?
Yes.
Your Lordship, this case has been filed by the petitioner, challenging the $15,000.
Is it on or not? Yes, it's on, yes. Yes, please.
Your Lordship, this writ petition has been filed by the petitioner, challenging the $15,000 interest amount that has been imposed on top of the $1 lakh fees that was imposed by the TRIMS, Your Honor. TRIMS, that
By?
is Tomo Riba Institution, Medical Institution.
Who has imposed this?
Respondent number 3. If Your Honor may kindly come to page number 15 of the petition. This is the nomination letter, Your Honor, that was provided to the petitioner. She was admitted into the medical MBBS course in the TRIMS institution, Your Honor. As Your Honor will see at the end of the page, point number 1, 2, and 3. The condition states that the payment of fee for
Why is
NRI.
it in dollars?
Pardon?
Why is it in dollars?
Because she has gotten admitted into the course by way of NRI sponsored quota.
Against NRI quota, madam. Yes, NRI quota.
Well, are you, you are appearing for the health department?
Yes, my lord.
But can you appear for the TRIMH?
My lord,
This impugned order is by whom?
This has been issued by the Director of Medical Education.
By you,
Yes, my lord.
That is respondent number
My lord, this is,
2.
two.
this was my lord, the part of the, it was the condition, requisite condition for admission. It is the case of 2019, my lord. She was nominated for the NRI quota, my lord, 2019, my lord. There in prospectus, it was clearly laid down, the condition. My lord, the first, if you make a full payment, in case of NRI, full payment, 1 lakh US dollar. And if you do not make any full payment at a time, then installment, in case of installment, 3-time installment, there will be 15,000 US dollar. That was, they've accepted.
You are contending that it is a part of the
The admission condition,
admission.
condition for the requisite condition for the admission, my lord.
Yes,
Having
madam,
accepted this, my lord.
what are your grounds of challenge?
Your Honor, my humble submission is that the total fees for the tuition was $1 lakh. However, what they've provided in the prospectus is that if we are going to pay the entire $1 lakh in one installment, not need to pay any interest.
Correct.
However, if it is paid in installments, that is 3 installments, 30,000, 40,000, 30,000, then in that case, an extra amount of $15,000 will be imposed. However, Your Honor, my humble submission is that this imposition of $15,000 is not only arbitrary, but it is also in violation of the right to equality guaranteed to the petitioner, because in case of other students, there is no such condition that has been imposed that for installment basis, these interests will be levied on, but only
Have
for
you
this
challenged the
particular
condition
case.
of the in the press? What is your challenge?
The only challenge is with
You
regard to
have
the
to challenge
15,000.
the condition, that there is a condition. If
Yes.
you have accepted the condition, how can you challenge? Number one, that question will come tomorrow. So, and whether you are in a position to challenge the part of the condition which you have already
Accepted.
you have accepted at that time, you have to make out a very, the onus is heavy upon you. You have to overcome that acceptance may not be a free acceptance. I was forced or I was induced, whatever. That is not your case even. You are simply challenging the imposition of interest of $15,000, which you have, is a part of the prescribed conditions.
Your Honor, it is also the case that according to the
Okay,
Medical
what is your name?
Council of India,
Heard,
T.Y. Bhutia.
heard Ms. T.Y. Bhutia, learned counsel for the petitioner who has put to challenge the action of imposition of interest of rupees $15,000
Yes.
by the director of by the Directorate of Medical Education, Training and Research, AP, for her admission in the MBBS course at the Tomo Riba Institute of Health and Medical Science on NRI quota. Full stop. It is submitted that the fee of rupees $1 lakh has already been paid by the petitioner, and therefore such imposition is not legally sustainable. Para, that notice be issued. On the other hand, Sri T. Tagum, the Standing Council Health Department, has submitted that the imposition of the interest is as per the prescription and condition of the admission itself. Para, be that as it may, let notice be issued, returnable by 6 weeks. Sri Tagum, the Learned Standing Council, accepts notice on behalf of
Respondent 1 and 2, 3, madam.
1, 2, and 3.
And 4 is RGU, madam, Rajiv Gandhi University.
Let extra copies of the writ petition be served upon him within 2 working days. Let steps be taken for service of notice upon the respondent 4 by registered post with AD. Para, steps within 2 working days. Please, after 6 weeks for service report as well as for filing of affidavits.
Deeply obliged.
Yes, Mr. Pada, what is it?
My lord,
Mr. Dole?
Yes, my lord, I'm appearing for respondent 6 and 7.
in fact, my lord, in the year 1965, my lord, our plot of land was taken over by the army, my lord, after the Chinese aggression, my lord. Thereafter, my lord, we had an agreement with the army, my lord, the Indian army. And that it was adjusted that the land will be taken on hire purchase, my lord, on hire basis, my lord. So they were paying us, my lord. But thereafter, they paid us till 2016, my lord. But thereafter, my lord, after the army left, my lord, that land was taken over by the SSB, my lord. And now what we are asking for is that, my lord, the SSB to, my lord, or otherwise, my lord, acquire the land and pay us compensation, my lord. That is the case, my lord. In total, my lord, the total area which was taken, my lord, was 10.15 acres, my lord. It was private land. It, my lord, there is page number 38, my lord.
Okay, in pursuant to the last order, you have filed the affidavit.
Yes, yes.
Okay. Yes, if the affidavits have been filed, we can hear this one.
We can hear it today also, my lord.
Today, are you ready for today?
I'm ready for today.
Okay, we can hear it. How many matters are there? Hearing also, no? If you are interested in having this matter heard for finally, you wait for some time. Let us finish the other matters.
My lord.
Okay. We'll have this after completing the matters.
My lord. Obliged.
Before the hearing starts, there are few matters in hearing
Yeah,
column.
this matter will not take time, but it will matter of 10 minutes.
No, there are few matters in
Yes.
hearing column.
Yes.
This will take as the last admission.
My lord.
After the
By the
orders
order, last two hearing matters are mine. That will take nearly 3-4 hours. So this matter will take only 10 minutes.
are- Okay, we'll take up this matter.
Yes.
Okay. Six to everyone, maybe? Item 6.
My lord, I am for the respondent, my lord. Union of India.
None appears for the petitioner on call, whereas Sri M. Kato, learned. Your deputy SJ.
My lord.
Deputy SJ is present. Para. Even on the last occasion, that is 11/25, there was no representation on behalf of the petitioner. Para. Be that as it may, and in the interest of justice, the matter is adjourned by 2 weeks. Full stop. It is, however, made clear that in case of further non-representation on behalf of the petitioner, this court may be constrained to pass appropriate orders. May be constrained, no?
Item 7, basically it is for payment of 100% solution basing on the judgment of this honorable court in Laling's case, my lord. That matter is pending before the Honorable Supreme Court. The 100% solution that was acquired under the Jumlan regulation, my lord.
Okay.
Well, in this matter, your lordship may see the last order 11/02/2025. The respondent, his representing Deputy Commissioner, he was given last chance to file affidavit. May I read the last paragraph of order dated 11/02/2025.
126 has not filed,
One
have not
is-
filed.
Yes. They were
Filed
given
or
a
not filed.
Not filed, my lord.
given
In
last
fact,
chance.
Because it, since the matter is pending, my lord, before the.
If you have not filed, then we'll proceed that you don't want to file.
Yes, that it will be recorded, your lordship.
But when is the matter likely to come up before the Honorable Supreme Court?
Tomorrow.
Tomorrow.
At least, my lord, may grant me time to file on behalf of the Secretary Land.
Petition, respond number?
1.
No, see, this
No,
order was passed in February 2025.
Yes, my lord.
We are in May.
My lord, respondent number 2. In fact, communication was made with the Deputy Commissioner. There is no response from the commissioner, but at least from the Secretary Land.
In that case, you have to file an application. We cannot just change the orders of this court.
That was with respect to respondent number
1 to 6 or 1 and 6.
1 and 6. My lord, 6 is the main.
I'll be filing for 2.
My lord, I'm for the respondent number 1, my lord. My lord, respondent number 1 has no role, my lord. It has been, my lord, done by everything.
Oh, you are for 2, Mr.
Yes, ma'am.
Okay.
Respondent number 6.
Third 3S Mao Learned Counsel for the
6 also, but 2 I'll be filing for.
Well, 6 also, I think, additional AG is appearing in this matter.
Yes, I'll be appearing for 6 also, but I'll be filing for 2.
Item 8.
for the
Six.
petitioners. Petitioners, they're more than.
6 is the.
Also heard Sri N. Ratan Learned AG
Yes.
for AG, Sri M. Kato Learned Deputy AGI and the Pada for and O Pada for respondents 3, 4 and 5. Para? When this matter had come up for consideration on the last occasion, that is IE 11/2/2025, a last opportunity was granted to the respondent number 6 to file affidavit with a further stipulation that no more opportunity would be granted to the respondent numbers 1 and 6 to file the counter affidavit. Para? The learned counsel for the petitioner has informed that no affidavit has been filed by the respondent numbers 1 and 6. Para? Sri Ratan, the learned AG, has however informed that the issue regarding payment of 100% solution is presently a matter of adjudication in the Honorable Supreme Court, and the said appeal is slated as a LATED to be listed tomorrow. Para? He further prays for some time to put to file an affidavit and also to put the status of the said case in the said affidavit. Para? In view of the above,
On behalf of respondent 2.
respondent number 2. In view of the above, the matter is adjourned by 3 weeks to enable filing of an affidavit by the 2, in which
6
the-
also, my lord. 6 also is represented 6 also.
No, 2, 6 has been barred. What did I say? What did I say? The respondent 2. Along with, in which the status of the case before the Honorable Supreme Court is to be put. Yes. Mr. Das, you are for whom?
Obliged.
My lord, is the next
Das
matter.
is online?
My next
Item
matter,
number eight.
item number 8, my lord.
Eight.
Item number 8. My lord, I am appearing, I'm sorry, my lord, I could not be there in Arunachal Pradesh.
No, no, no,
So,
no problem.
so
What is it?
I have taken permission from one court master to sit here and do the matter from here, my lord. My
No, no
lord,
problem. Yes, please.
yes. My lord, this matter is pertaining to a particular land acquisition where acquisition has not taken place. Acquisition has not taken place by my land has been utilized. From 1985, it was under Assam Rifle. 2005, it was taken by ITBP. Now we made several representation to the authority stating that this is a land belong to community land. So at least there has to be some acquisition. They should take over and accordingly the compensation should be paid to us, or either the land which is utilizing by ITV, they should pay the rental lease to us and they should vacate it. If they doesn't want, then let it vacate to give it back to us. This was our case and represented the matter before the authority, my lord. Several representation was made. And subsequently, we got some RTI also, where till today also the land has not been allotted to ITV. It has not been allotted. It is the affidavit which has been filed by the government also. So our whole case was very simple, that the government should take a decision and they should issue a notification for acquiring the land, acquiring this land, and they should calculate and accordingly they should pay to us. That's our whole case, my lord. Till today, they have not done anything. And we are suffering. These are community land. This is our whole case before the court, my lord.
Yes, what do you say, Mr. Katul?
Malad, we have filed affidavit.
Yes.
By affidavit, Malad, it is very clear that the land has been, Malad, transferred in favor of the ITBP, Malad, from the Malad Assam Rifle, Malad. And compensation amount has also been paid, Malad.
Paid to whom?
Paid to the Malad department, Malad. Lordship,
No,
pay,
was the Assam Rifles the owners of the land?
yes, Malad, as per the allotment, Malad. There has been, Malad, with the approval, Malad, the Ministry of
You are also appearing for the Assam Rifles, aren't you?
No, Malad, Assam Rifle is no longer in the Malad station, Malad. That has been handed over.
No, no, see, now to hand over, either Assam Rifles have to be the owner or the lessee or something.
Malad, as per the Malad, the approval,
What was the
Malad,
status of Assam Rifle?
Assam Rifle was the owner, Malad, as per the transfer, Malad, given to the Assam Rifle by the state government.
Assam Rifles was the owner.
Malad,
How was it allotted to your vendor?
Malad may kindly peruse the Malad, the order, Malad, approval, Malad, which we have annexed also, Malad.
Page,
No,
Malad,
no allotment.
page number?
In fact, RTI to the page 2.
page number, Malad,
280.
358, Malad.
388.
280. Page 280.
Annexure 1, Malad. Filed by the ITBP, Malad, on 28 February 2025, Malad.
388.
58, Malad.
358.
358, Malad.
There is no 358.
This is the continuation of the Malad, the read petitions and Malad, the affidavit filed by the other respondents.
Okay, here. Okay. Yeah.
Page number 358, Malad.
It is a proposal, second allotment,
Married, Malad.
Yes.
Transfer of lease over the diversions of the so-and-so area of forest land for accommodations of two Assam Rifles troop at Lohitpur and then in Lohit district of Arunachal Pradesh.
Yes.
I am directed to refer to the letter number so-and-so, dated so-and-so, on the subject cited above. The seeking prior approvals of the central government under the Forest Conservation Act 1980. After careful considerations of the proposals by the Forest Advisory Committee, they constituted under section so-and-so of the said act, in principle approvals was granted with by this ministry's letter of even number dated so-and-so, subject to fulfillment of the two conditions prescribed therein. The state government has furnished the compliance report
in respect of the conditions stipulated in principle, the approval and has requested the central government to grant final approval. In these connections, I am directed to say that on the basis of the compliance report furnished by the state government by letter number so and so, dated so and so, and DO number so and so, dated so and so, on the subject cited above, the seeking to final approvals of the central government under Section 2 of the Forest Conservation Act 1980, the central government hereby grant approval for the transfer to the lease over diversion of so and so hectare and has the forest land for accommodation of so and so Assam rifle to set the so and so. Approval has been given by the government. So therefore, this has been the transfer to the Assam rifle.
No, we are not on the aspect of transfer. We are on the aspect of the ownership of the land.
Ownership, the ownership has been given by the state government with the approval of the competent authorities, madam.
Where is it? Where state governments declaring ownership?
My lord, 1 second. If your lordship, I'm troubling with you 280. There is a clear RTI. Kindly see 280, my lord.
280.
280. Kindly see, I made an RTI. And RTI, they have informed that no allotment has been made as on 14th of November 2024. Kindly see at 280, page 280 of the writ petition. See the 280.
Yes.
14 November 2020. This is the RTI Director of Land Management written to this Rohit Mele. As per direction of Secretary Land Management in his order number so and so, 8 November, which is in persons order passed in so and so, the following information pertaining to plots of land measuring 318030 hectares and 41 acres of land, which falls under us 97 point so and so. Occupation of ITB is hereby furnished. A. Furnish the detail whether one-time revenue premium has been paid or not. If he has furnished the detail, DNA in view of B. What is B, my lord? Furnish the details whether the land has been allotted to ITB or not. If he has furnished the land allotment details, no. So there is no allotment which has been given to ITB as on date on 14th of November 2024. No allotment. So how my learned friend is saying that some proposal they have sent it, but that proposal has to be approved. And there is no allotment which has been made to ITB. How they are claiming that it is their land? How they can say?
And regarding the payment part, if lordship peruse that
Payment, I'll give an answer.
Para 8, Para 8, wherein it has been categorically stated that the compensation in respect of the said land has been paid to the paid.
Who has paid to whom? ITBP has paid to Assam Rifle.
Yes, ma'am. No, ma'am. As far this has been already paid by the Assam Rifle, ma'am.
To whom?
To the government, ma'am. Paragraph 8 of same affidavit, ma'am. Page number 354, ma'am.
354.
154, ma'am.
Yes.
Para 8, madam, I'm reading. The deponent humbly submits the payment of Rs 1 crore 13 lakhs 45,000 only for compensatory afforestation was made by the second Assam Rifle throw chala number so and so, dated so and so. Rs the 86 lakhs 6,500 throw so and so, madam, and on that is for so and so. And madam, another payment is 27 lakhs 38,500 with receipt of DFO Teju that dated 2001, sorry. Since it is the forest land, same has been already the deposit, the payment has been made to the forest department, and the same amount has been duly acknowledged.
Where state council, what is the status of this land? Is it forest land?
Just I'm para 11, I am completing. Just for a moment.
11,
11, man. Just
please read.
para 11, man. The deponent humbly submits that the total area of so and so hectare land is in possession of the 9 BN ITVP, which was handed over by the Assam Rifles to the ITVP in the year 2004 and 5. Man. This land was earlier diverted to the second BN Assam Rifles by numbers, Ministry of Environment, Forest. So and so, mentioning the complete the land is forest land, and subsequently the above land measuring so and so hectares transferred to the ITVP 9 PN ITVP by Ministry of Forest and Environment letter number so and so. This is the the factual position. And again, may I take your lordships to the para 13, last next page, I'm skipping the first portion, next page.
Yes,
Deforestation.
yes.
The ITVP was approved by the central government by letter number so and so, dated so and so, 7/7/2015. Copy enclosement. The government of Arunachal Pradesh, the Department of Environment and Forest, the Itanagar by letter number dated so and so, which strengthened that the piece of land is a forest land. Accordingly, the transfer of lease of so and so hectares, the forest land was diverted to the Assam from Assam Rifle so and so to the 9 BN ITVP 4, which RS 1 lake was deposited in lieu of the lease transfer on so and so to the adopter. Some subsidies, it is a forest land which has been which was given to the Assam Rifle. Again, that has been too covered by the ITVP Even transfer of the lease that has been initiated and paid the 1 lakh rupees to the state government. So therefore, this is the extent of the
Mr. Ratan, what do you say? Is it forest land?
My lord, although
Because
it
their
was-
entire claim is that it was forest land, their vendor, let us use the expression vendor, from which the land has been transferred to ITBP. Assam Rifles was the initial, they were in possession. And Assam Rifles was directed to pay compensatory allowance for deforestation.
Yes.
Because this land was given to them, forest land.
Yes.
What is your stand? As the state government, what
uh,
is your stand? Because petitioners claim
My lord,
that the
before,
land belongs to
no, no.
them.
Yes, before that, my
May I
lord,
clarify, my lord?
Yes.
my learned friend, Mr. Ratan, argues the matter. I will show before this court by an RTI that entire land is not a reserve forest land. It is your lordship will
Madam,
find at
that-
page 257.
Oh,
See page
we'll come
257.
to it. We'll come to it. We'll come to
Yes.
it, Mr. Das. Just a minute. Just
My lord, there are different categories of forest land. my lord.
yes.
Reserve forest and classified state forest, my lord. Wildlife sanctuaries and all. my lord.
Hmm.
Now, reserve forests, these are being reserved, Anchal Reserve Forest or wildlife reserve
Hmm,
forest.
hmm.
These are being reserved after a due process, my lord, giving notice and they're notified.
Hmm.
That the rights of some individuals are recognized under the reserve forest.
Hmm.
That basically becomes under the domain of the government. my lord.
Hmm.
But unclassified state forests, that although in the records, there are recorded as existing forest, but they are not acquired by the government. They are existing forests. The ownership lies with the individuals or the community. Although it's a forest land, unclassified state forest, but the ownership, because it has never been acquired by the government or it has never been notified as a reserve forest. So the ownership remains with the community or the individuals. So in such type, my lord, when reserve forest, any type of forest, including unclassified state forest,
Yes.
when it is diverted
Yes.
for non-forestry purpose,
Yes.
then the user agency, we will have to obtain clearance from the Ministry of Environment and Forest, my lord. There they have to compulsorily, whether it is any type of forest, my lord, reserve or unreserved, it has to be compensated. They have to deposit the compensatory afforestation to the forest department so that they utilize it for further forestation, afforestation. So this is but that does not mean, although compensatory afforestation that has been given to the department, it doesn't mean the ownership of the individuals under the unreserved, unclassified state forest will change. The ownership remains. Only they will not get any benefit of that forestry compensation, CAMPA, under the CAMPA, but the rights over and that their properties over that forest land, unclassified state forest, that will with the community or the individuals, since it's not been acquired by the government. Now, in this particular case, Malad,
Now, it boils down to this few issues.
yes,
What is the total area of land involved?
yes, Malad,
Number one.
I'll take
Number
your
one, just listen to the questions. Then out of the total area, what is the area which consists of reserve forest land?
Yes, Malad.
Reserve forest land, where we may tentatively come to a conclusion or one agreement that reserve forest, no community can lay any ownership. It is already reserved.
Yes.
Now, what is the part of unclassified forest?
Yes.
Where the rights of the community or the members will still be there.
Yes.
Whether they are entitled to compensatory allowance, that's a different issue altogether.
Yes.
But once we can identify that out of the total area, certain areas would also fall under the unclassified forest, the rights of the community is still there.
Yes.
Then the question of compensation would definitely come.
Yes, Malad. In the
Simply saying that we had paid the compensatory allowance for under the CAMPA for afforestation purpose, that will not mean that their rights, if any, have been compensated
Yes.
in lieu of the acquisition made.
yes, Malad.
So we want to assert and say there are factual disputes, but
Malad,
if we can come to a conclusion that
yes.
out of this area, this suppose A area, out of A, B area is an area wherein this petitioner were having their rights.
Yes,
And their rights have been affected because of this handing over, taking over.
Malad, in the affidavit of the forest department, we have clarified what are the areas, Malad, at page 328.
328.
28. Yes.
Yes, please.
Malad, preliminary facts of the case, Malad.
Yes.
The land situated Udoy Majam Reserve Forest was notified by notification number so and so dated 1978 by the so and so under section 17 of the Assam Forest Regulation so and so there. Then two, my lord, an area of 145.41. Here, 84.33 hectares in Udyam Reserve Forest and 96.977 hectares in USF non-forest land was diverted in favor of Assam Rifles by letter dated 25/3/2002 and subsequently transferred in favor of ITBP.
So here you have
Here-
specifically mentioned two. One is 48.433 hectares in the RF, and the other one 96.977
7
hectares
hectares in USF.
non-forest,
Yes, unclassified state forest.
non-forest land, unclassified state forest.
It is the forest land, but it is not of the government. It is by the individuals or the community.
So this, if you are saying that this 96.977 is not reserve forest, wherein 96.977 hectares
Yes,
is not reserve forest,
not reserve.
it comes under the unclassified state forest. Maybe it's a forest area,
Yes.
but owned by the community.
Yes,
And what about the compensation for at least for this area?
yes, my lord. That they will be entitled. The compensation not under the reserve forest, but on unclassified state forest, they will.
No, had it been a reserve for a question of entertainment would not have come.
Yes, madam.
Because reserve forest is the government who is the owner.
Yes, madam.
And in case of any deforestation activities, the allowance have to be paid. And that is not exceptional circumstances.
Yes, ma'am.
Now, as on now, deforestation is totally almost absolutely banned.
Yes, ma'am. So that is there, and this fact also, my lord, will come to the affidavit of respondent number 7, that is by the deputy commissioner at page 365. This is how the deputy commissioner has tried to make out the facts of this case, my lord.
Yes.
Status
is it?
report of the land at
Yes.
365. my lord.
Yes.
The land allotment proposal was received from Second Assam Rifle for 327 acres on 1987. Further, this office received a letter from Joint Director Land Records Narlagan regarding acquisition of 327.30 acres of land at Lohitpur to Second Assam Rifles on so and so, which was submitted to Land Records Department by Commander. Fresh reminder request letter was received from Second Assam Rifles on 23/8/1988 and 8/9/1988. Progress report of the land acquisition proposal of Second Assam Rifle was sought by Joint Director on 27/9/88. The Joint Field Survey Order of Land under occupation of Second Assam Rifle was issued on 6/10/88. Joint Field Survey was conducted on 19 so-and-so. Report was received on 31/10/88. As per ground survey, total area under occupation of Second Assam Rifle is 278.3 acres. Therefore, allotment proposal for area falling under USF measuring so was sent to Secretary Revenue and Settlement so-and-so, Government of AP on 13/12/88. Further area measuring 119.68 acres falling under reserve forest out of 278.330 acres was initiated for de-reservation in consultation with Forest Department. The letter was received from Joint Director for obtaining clearance from Forest Department for diversion of USF for non-forest purpose measuring 158.62 acres to Second Assam Rifles on so-and-so. Clarification to the above query was sent on 31/1/89 to Joint Director Land from this office. A letter from CF Eastern Circle, Teju, was received on 1st May 1988 stating that the area under occupation of Second Assam Rifle is at any stage been formally allotted to them by competent authority before 1988. The status submitted on 5/5/1981 to CF Eastern Circle giving the status of land under occupation of Second Assam Rifle at Lohitpur that it is not formally allotted as on date. A letter addressed to Joint Director LR for early approval of land allotment of land under occupation to Second Assam Rifle on 23/6/89 and 30/10/90, and in the meantime a proposal was sent to DFO Teju on so-and-so for diversion of 119 acres of RF land under occupation of Second Assam Rifle. The MOEF accorded approval in principle for diversion of 145.45 hectares of forest land under occupation of Second Assam Rifles at Lohitpur, dating on 24/2/2000. For the final approval for diversion of the land under occupation of Second Assam Rifle was accorded on 5/3/2002, but legal status of the land will remain unchanged. My lord, till here, my lord, everything is clear, my lord. After the diversion, from here, the facts, what comes out is that Assam Rifle is in occupation of vast area, my lord. Out of this vast areas, some are forest land.
Yes.
The forest land, out of the forest land, some portion is reserve forest, some are unclassified state forest. Now, after the diversion of this forest land, combination of both forest, reserve forest and the unclassified state forest. Approval was given by the Ministry of this Environment and Forest, which they claim that the compensation has been met. But for diversion, Kempa, they have to deposit, my lord. That is under the Forest Conservation Act, my lord. Now, this office has sent, the Deputy Commissioner is saying that this office has sent a draft notification for acquisition of land under LA Act 1894 to the Secretary Land M on 13/8/2002. Now, here what has happened, in response to the aforesaid proposal, the Director LM responded the proposal on 8/10/2002, wherein it stated that two locations of land under occupation of Assam Rifle measuring 318.30 acres and 41 acres are de-reserved forest area, and hence de-reserved forest area becomes a government land. Here, because of this stand, maybe the land acquisition process could not. Otherwise, the Deputy Commissioner has initiated because of this observation by the Director. Therefore, the question of acquisition under LA Act does not arise. Otherwise, maybe because of this, what the incorrect proposition that since it has become de-reserved, so it automatically becomes the government land. That's then maybe of the.
But the entire, these two plots of 318.30 acres and 41 acres was where these two areas consisting of reserve forest. That's the question.
My lord, in fact, 145 acres, if my lord has seen from the DFOs, out of 145 acres, what has been de-reserved is 145 acres. Out of 145 acres, hectares, certain area were under the reserve forest and certain were
No, as a state council, you tell us. Of the entire area involved, we are only concerned with the claims of the petitioner.
Yes.
The petitioner cannot claim any compensation over a reserve plot of land.
Yes.
Reserve forest land.
Reserve forest.
Their compensation would be confined to unclassified forest land, which they were the owners, or
Yes.
community was the owner.
Yes.
So we want the area over which there was unclassified forest land.
My lord, that is.
I'm sorry,
in the earlier
sorry to
affidavit.
disturb.
Yes.
Sorry to disturb my learned friend. Your lordship is putting a very pertinent question in this case. So, if your lordship looks at page 266, kindly see at page 266 of the of my writ petition, because my learned friend has covered his case, but your lordship want to see identification of land, which is reserved and which is USF. This your lordship will find at 266. 266 of the writ petition.
Yes, yes.
See of 9 September 2024. That was an RTI. In 9 BN ITBP Lohitpur, first queries, situated Uddam, lordship got it?
Yes, yes.
So and so, if not situated Uddam reserve forest, then may kindly furnish me a detail of the efforts seeking information by written. The land occupied by 9th BN reply at Lohitpur was diverted in favor of second AR, white so and so for an area of 145 of 41 as per below land breakup. Uddam Mazan RF 48.33 hectares, Denning USF 16.60, USF Lohitpur 80.377 hectares. So total come to 145 for 41 hectares. Now, my lord, second, is ITBN, ITB Lohitpur situated in any notified reserve forest? The 9 BN is situated in reserve forest for 48.433 hectares in so and so, and 96.977 hectares in US area, that is outside RF area. So this is the answer, my lord. Your lordship is asking, this is the answer. It is outside 96.97 hectares in USF area. That is outside RF area. That's the case, my lord. My lord, am I clear, my lord?
Yes, yes.
This is what? This is what my learned friend My Ratan was showing to your
Yes.
lordship at his reply 329 at 2 in his affidavit. So I think this is very clear now, my lord. This is a reply which is given by the divisional forest officer itself. Kindly see who has given this. DFO.
So from this document, Mr. Das at page 266,
Yes.
it appears that 96.977 hectares is unclassified land,
Correct.
unclassified forest land.
Yes, madam.
So your compensation can minimum of this area, at least for this area, each has to
Yes.
be calculated.
Yes,
And
that
for
is our
that,
case. Yes.
For that, either you have to initiate a land acquisition proceeding,
Correct.
or
madam.
since the land has been utilized by them for all the years, they have to give you requisition.
Requisition, they
amount.
can give it, or my lord, till they require it, or my lord, they hand over the back to us, or they go for a fresh requisition. The acquisition notification they may issue. And so far as the Kempa is concerned, my lord, that is my learned friend as well addressed, and your lordship will find a rehabilitation and resettlement policy of 2008. Government of Arunachal Pradesh at chapter 6, my lord. Chapter 6. What is Kempa? That is 6.2. 6.2, that is Rehabilitation and Resettlement Policy 2008. Rehabilitation, Resettlement Policy 2008 amended. That your lordship will find. Yes, I think my learned friend Mr. Rava is if he's having, then he can hand over this copy to your lordship. That your lordship will please mark chapter 6. This is chapter 6. Chapter 6, Rehabilitation and Resettlement Policy. Chapter 6, that is 6.2. 6.2. They said that 1 crore has been paid. That is your lordship will find at 6.2. Why this 1 crore has been paid? 6.2. Page, this is page 23. Internal page is 6, my lord, of Rehabilitation and Resettlement Policy 2008. I am, my lord, my learned, it is not annex. I can hand over a copy. My learned friend Mr. Rabba will hand over that copy. Rehabilitation, Resettlement.
Sorry, Mala, I do not have that, Mala.
RNR policy, my lord. I think Mr. Ratan may have that. It's a government of Arunachal.
No, Mr. Kato, from this document at 266-99-2024, which has come from the government, it clearly appears that 96.977 hectares is unclassified forest land. What is your take on that? What have you decided? You have been utilizing this land. This is not reserve forest. Your payment of compensatory allowance will not come within this unclassified forest land.
May I take your lordship to page number 366 again, madam. Last question.
Page 56. Yes.
Affidavit filed by the respondent number 7.
Yes.
Now, the user agency activity may be directed to submit press requisition letter is per LA Manual 2022 to the competent authority. As per the record available in this office, the area under occupation is the reserve forest area, and the current legal status of the land will be unchanged as per the final diversion notification issued by the so by Ministry of Environment Forest Development. So therefore, madam, this is the extent of the Union of India, madam. Still, madam,
So this affidavit at 360 is by the circle officer.
This is by the Deputy Commissioner.
Deputy Commissioner.
Boss.
So the circle officer is the deponent
Yes.
on behalf of the Deputy Commissioner.
Deputy Commissioner.
He has made his position clear, and this communication at 266 clearly states that at least 96.977 hectares is unclassified forest land.
that is subsequent to the
These are factual determination. Either you will have anything to say, nor Mr. Abha would say. They will obviously claim much. But once the determination is done by the state,
subsequent to the payment which has already been made for the entire area.
No, that payment is for that area is not for acquisition or requisition. That payment is for compensatory allowance for using forest land.
Diversion of
That,
forest,
because it was de-reserved.
yes.
Lordship has seen on 4 occasions, my lord, the amount.
No, what will happen? What will happen to the claim of the petitioners?
But in that case, to that aspect, my lord, may I pray that, my lord, I may be given some more time to, my lord, ascertain the factual position.
No,
Well,
well, see, factual positions are before this court, unless you dispute 266, 2024, which perhaps you have very limited scope of disputing. These are matters of records.
As per the affidavit given by the ITBP, my lord, it is in respect of entire area.
See, these matters are, if the approach to the court is bona fide, these are not adversarial litigations.
Right.
These are part of the schemes that if you acquire any land, if one is entitled, there would be a reference where there would be respective claims. They have to prove their claims, market rates, there are parameters laid down in law. You follow the parameters, give the compensation. This is the entitlement in law. We are not saying that somebody will have an windfall in the name of acquisition. This is also happening. We are aware of that. We have to be alert. But you cannot say that we are not going to pay compensation. It's not, this is a part of the law. It's a legal system. That if you acquire, you have to pay compensation.
And yet, my lord, the meaning, my lord, the land has been given to the Assam Rifle following the law, my lord. And compensation has already been paid to the matter.
No, that is not the compensation. The Assam Rifles payment by compensation, the payment by Assam Rifles is only pertaining to compensatory allowance for de-reserving. And here, ultimately, it has come out on record that out of the total area of 145.41 hectares, at least from the communication dated 9/9/2024, out of this 145.41, 96.977 is unclassified forest land.
That is the only extent taken by the ITBP. Madam, for entire area, madam, the amount has been paid.
What amount?
Madam, the compensation amount.
No, not compensation. It is compensatory allowance.
This is, madam, the contents of the matter.
My lord, may I clarify? Compensatory afforestation that allowances has to be made for reserve forest also or
Unclassified, yes, yes.
any.
No, that is not amounting to compensation to the persons
Yes.
affected.
Yes.
Had it been forest land owned by the state, like reserve forest, then their further liability would not arise.
Would not have
But
arisen.
if it is unclassified land, which appears from 266,
Yes.
their liability will not end
And
only by paying
the
compensatory allowance. They
afforestation,
have to,
yes.
the aspect of acquiring the land or requisitioning the land would also come.
Yes, ma'am.
I think your land management department has not
I
understood.
will just
That at that point of time, maybe it was not understood at that in the right perspective, because they have just assumed that once it is de-reserved, now it has become government land. That's not the correct stand, my lord.
What can you de-reserve? You can only de-reserve a reserved land.
Yes,
You cannot de-reserve an unclassified forest land.
yes.
Yes. But
My lord,
the
the-
aspect of paying compensatory allowance may still arise in an unclassified forest land.
Yes,
But that is not amounting to de-reserving the land.
yes, ma'am.
Yes.
In fact,
My lord, I will just give a
Mr. Das,
Yes.
we are.
recently there was a judgment of this honorable court.
Yes.
But the acquisition process was by the power grid. In that also, the concept of unclassified state forest, this honorable court has directed to pay compensation, my lord. Paragraph 15, my lord. My lord, as per orders passed by the Honorable Supreme Court, paragraph 15. It should have been from time to time, the forest land consists of area remains the forest land. However, the state like Arunachal Pradesh has a peculiar system of ownership over land customarily either by individual or community. On perusal of the records, although various approvals have been granted by the different appropriate authorities for diversion of said land for construction of 132 kV transmission line under comprehensive scheme, unless the land being owned by the people, including the petitioners, are notified as reserve forest.
Yes,
the right,
this is exactly what we were
yes, ma'am.
discussing.
Yes,
There has to be a difference between a reserve forest
and
and an unclassified forest land.
yes,
So for a reserve forest is concerned, the ownership lies with the state. And if it is de-reserved or used by any agency, then they have to pay compensatory allowance.
Yes,
But the matter is entirely different if it's an unclassified forest land.
unclassified.
The ownership doesn't lie with the state,
Yes.
though it's a forest land.
Yes,
So if it is given to somebody, it has to be given by following the due procedure, which is either by acquisition or requisition. Number
Yes.
one, since it's a forest land, maybe unclassified, the aspect of payment of compensatory allowance in addition to the compensation
yes,
will also come.
yes, ma'am.
That
That
is
is,
the stand.
That is clear because of chapter 6. I'll just read one paragraph of chapter 6, which my learned friend Mr. Khato has said that we paid the amount.
Where is it?
Rehabilitation and Resettlement Policy
No,
2008.
that has not been given. Unfortunately, that copy has not been given to us.
Yes,
No,
I will
don't give
just,
us.
I'll just
It's
hand
not
over
there.
my.
It is
I
not
thought
there
that-
with your local council, unfortunately.
My lord, can I just read one paragraph with your lordship's satisfaction? I will hand over.
We'll do
Just-
one thing, we'll have this on Thursday. You
Okay.
bring the,
Okay.
and we want one aspect very clearly, and which is also to be endorsed by Mr. Kato, that regarding the area of land which falls under USF. You have for reference 266 is there, 365 is there. There should not be any dispute in this. What is the actual compensation they will be ultimately getting? You have all the rights to oppose that this is not the actual amount, they should get less or they should get more. This will be adjudicated by the appropriate authorities. We cannot determine the compensation as on today, but we'll certainly direct for either for going for an acquisition proceeding or requisition from the deed. And if you give an acquisition proceeding, it will be done in accordance with law. But they cannot be left high and dry that you are utilizing their land, not paying anything. Cannot be. Day after tomorrow. And
My lord, yes,
whatever
I-
documents are done.
Yes, yes. I may be there, my lord.
Clear understandings of the IDBP is when once the compensation is already been paid.
No, you,
Kemp-
see,
Kempa-
see, apart from you being the deputy AGI, you are having a much significant and greater role as an officer of the court. You make them, they may not be, they should also understand, but this payment of compensation is a very vague term. What compensation? Is it compensatory allowance for de-reserving? Or is it compensation for requisition? Is it compensation for acquisition? Simply paying an amount is not enough. It has to be under the proper head. You explain it to them.
Yes.
Okay. And we'll also consider this judgment too.
yes, ma'am.
Heard Sri D. Das Leonard, Senior Counsel, who has appeared online and is assisted by Sri S. R. Rabha. Also heard Sri N. Ratan, the Learned AAG, as well as Miss, or as Sri M. Kato, Learned Deputy HGI. Well, after hearing the matter at some length, the same is adjourned to be called again on Thursday next to enable the Learned Council to obtain further instructions. Okay.
Obliged, ma'am.
Deeply obliged.
And the state respondent is supposed to file a affidavit, madam. So, madam.
My lord, we require some more time, my lord.
What is the matter?
It is the matter pertaining to the illegal appointment, matter. The SIC investigating agency, they submitted a certain numbers of the MTS matter.
Okay, how much time, Mr. Thakur?
My lord, we sought for, since these documents not with us at directorate level, so we sought for the clarification from the concerned district DDSA, and we are yet to receive, my lord. This is why, my lord, 3 weeks time may be granted, my lord.
Okay, heard Sri M. Kato, Learned Counsel for the petitioner. Para. Also heard Sri T. Tagum, Learned Standing Counsel,
Education Department.
Education Department, who prays for and is granted 3 weeks further time to file the affidavit in opposition. List up to 3 weeks.
Deeply.
Petitioners, huh? There are many.
Deeply obliged. Madam, it is made fair. Madam, may I pray that, I'm sorry.
Yes.
My lord, I'm appearing on behalf of Union of India.
Yes.
So, my lord, may I afraid that my
Who is
lord,
appearing for the petitioner? Item number? 10. Who is for the petitioner?
my lord, earlier Mr. L. Bam, my lord. Sorry, B type of the my lord was appearing. My lord.
Where is he?
My lord, today he's not present, my lord. Otherwise also, my lord, we may be given some more time to my lord the
None
openness.
appears for the petitioner on call. On the other hand, 3 M. Taku, learned deputy GI. Place 4. And is granted 3 weeks time to file affidavit in opposition.
My lord, 4 weeks time. my lord.
4 weeks time. Sri Suvansu, learned state council is present.
Deputy President.
Your Lordship, I'm appearing for the petitioner. Your Lordship, I pray for some more time to file affidavit in reply.
You want to file reply affidavit?
No, Your Lordship.
On the prayer of Sri Suvansu learned counsel for the petitioners, 3 weeks time is granted to file rejoinder affidavit. 3 and Ratan learned AG is present for the state.
Yes. All right.
Lordship, here in item number 21, I'm for respondent number 3, Lordship. It's a connected, Lordship, here the question involved is where the appointment of head Gambura, Lordship.
Okay.
Since Lordship, this court has stated the matter in item number 21, WPC 147, 2009. Since Lordship, the villagers are facing a problem, whether like to conduct a village level kabang, they have to write the letter to the head Gambura. Since Lordship, the matter has been stated, the appointment of head Gambura has been stated, so the villagers are facing problems. So
Now,
this
if you are
matter,
insisting, we can try to resolve the matter today itself.
yes, Lordship.
Yes, my lord, I am for WPC 253.
Okay. Which is the lead case? Who would like to argue in this matter? You decide. If the issue is connected,
Yes, sure.
you can hear one of the council, then other council may add if anything is left out or simply endorse. You are in item number
Item number 21, your lordship.
21.
Yes.
What is your good name?
Good name, T. Dada.
T. Dada. Okay.
Yes, lordship.
The petitioner is also T. Dada.
Tadung Dada.
Hope you are not the petitioner.
No, I'm not petitioner, lordship.
You are the counsel for the petitioner.
Yes, your lordship.
Okay, if you want to argue, lead the argument, you can very well. Yes.
Yeah.
Yes,
Lordship.
you are for which matter?
Lordship for item 22 and 23.
22.
Yes.
23. You are opposing or for the petitioner?
In item number 21, 22, I am the petitioner man, and 23, I am the respondent.
23 is against you.
Yes.
Okay, interesting. Okay, well, if you want to have the matter, we can definitely have the matter. Yes,
Yes. My lord, may I submit your
all the councils are present.
Yes, Lord.
State. You'll be there. If you want, they can start. You can join.
Lordship, before this honorable court, yes, Lordship, similar case was listed before this honorable court. The honorable court has disposed of saying that since this is an appointment of head Gambura, the appellate authority is deputy commissioner, which is their Lordship. This is the judgment, Lordship.
Yes, what do you say, Mr. Dada?
My lord,
Show it to him.
my lord,
If it is covered by the same judgment, we will not spend much time.
my lord, my case is, my lord, regarding the cancellation of the head GB appointment order, my lord. In my writ petition 253, I have challenged the legality and validity of illegal cancellation of the head
Now,
DP.
if you have an appellate authority which can adjudicate your issue. You file an appeal, it's a fact-finding authority.
Here, Lordships, there is a guidelines, Lordships, rule 2005, Lordships. And I was cancelled by the Deputy Commissioner, respondent number 3, Lordships, without following the principle of natural justice. No notice was issued, and rules 8D says, Lordship, in the dismissal of the HGB and GB, there should be followed the principle of natural justice. At the initial stage, there is no any notice issued to me, Lordships. This is my difficulties, Lordships. And now my second submission is, Lordship, I have disqualified as per this respondent number 3. I mean, it's contention. I am well qualified, Lordships. My date of birth is 18/11/1970, and now my age is 50 years, counting from the date of appointment, Lordships. So I'm well within the qualified age, Lordships. So apart from this, I have submission is that, Lordships, a person who is complaining, Lordships, against me, he is deeply associated with political party, Lordships. So rule says clear. No political party can intervene into the appointment of GB and HGB.
See, who is appearing in your, the other case, the private respondent? Who is the private respondent?
Private respondents counsel is not to prepare today.
Who is the counsel?
My lord,
No, we don't mind taking the matter today or tomorrow, but all of you needs to be present. Because all the many councils are involved. We don't want the matter to be heard in the absence of some council.
my lord, may kindly
If it's comfortable tomorrow for all of you, come tomorrow.
my lord, today itself. My lord, may kindly see order that.
No, your friend is not there. He is praying for some time till tomorrow. It's not a long, unreasonable adjournment request for tomorrow.
Or Lordship, we can take adjourn the matter and take it after some time.
After some time, will he be available? After some time? Okay, then we'll have it after some time. There's one matter of Mr. Dole, we want to give precedence. After that, perhaps. Yes.
Much of it.
Made below, sir.
Yes. Item number?
26.
Yes, please. What is the matter about?
Regarding the pay fixation, my lord. Pay fixation. Pay.
Pay fixation?
Yes.
Okay. Who's opposing you?
The medical department, Director of Health.
Okay. Can you?
My lord,
It is for admission, yes. What is
it can be listed for admission, but my lord, we have taken a category saying that although their case was processed, my lord, but administrative reform, the department, they have turned out the file saying that that there's an instruction to the government that till the next 7th pay commission report is submitted, the enhancement of the pay scale cannot be put up. Accordingly, because administrative reform is the main matter. In case it is rooted through the administrative reform, then finance matter. Now, in the middle way, matter, when we need,
Madam, we are for administrative reform.
it's not a party here.
I'm for finance.
Why don't you bring the administrative reforms?
It is there, my lord.
No.
But here,
Is it there?
administrative
It's not
reform.
there.
Which one? Respondent number?
7, Secretary Department of Personnel, Monitoring and Operation. This is he is the Secretary of the department. Respondent number 7, my lord.
Administrative reforms is a separate independent
Separate.
department.
Yes.
Respondent number?
7, my lord.
Personnel ka monitoring and operation, this is not administrative reforms.
Yes, my lord, he is controlling.
No, no.
We have checked it.
Administrative reform.
AR is a different department.
And we have checked it, but it is the person, the secretary personnel, and
No, if your submission has to be endorsed by them, then only we can go ahead.
they have to check it first.
Cannot be a disputed who's the necessary. If you
Absolutely,
say-
my lord, they have to check it because they have.
Yes, what do you say, Mr. Tan?
My lord, that is what we are saying, administrative reform, my lord, especially there's a separate department, administrative reform, my lord. Now,
See,
administrative
make
reform,
them a party. See, it's not a very tough job on your part. There's a government council will be appearing. Madam can only appear. Make them a party, formal party, that's all. You can give a direction to the administrative reforms. Make a one-page application.
unless if the file is clearance by them, my lord, it cannot be, matter cannot be go ahead, my lord. That is why, my lord.
Even otherwise, pay anomaly. These matters are within the domain of the body which is constituted. We can only give a direction for a fair treatment. You make this AR a party. Make a one-page application, have it on.
Here is actually generally my lord, district administration and public grievances and reforms. On my check, on my visit, my lord, I have seen and consulted with the branch officer who has said this is the same person who is controlling everything, my lord.
No,
Or if they can,
your instructions may not be correct. The instructions from your client may not be correct. The state council is saying, why should we disbelieve the state council? You make the administrative reforms a party. Have it on
you know,
Friday.
fact of the case is that the same department, under the health department, all other nurses, right from the peon to up to, my lord, all categories, they have their pay has been already revised, my lord.
My lord, that is why that.
And 7 pay commission already completed. Now 8 came into being.
My lord, that file, whatever it may be, it has to be rooted through the administrative reform, my lord. Once administrative reform is done.
Mr. Modi is insisting on the consideration of this matter, we can have this matter without even including. If the aspect of including comes on later, then we'll not be able to help you. But if you can make out a case without that being a party, here we will consider your matter, pass appropriate order. Yes, on Friday for admission hearing.
I don't think I may be allowed to for the implement of that party.
We are insisting on you are hinting on that, you are saying you don't want to.
This is my lord, my personal.
What we are saying that you make them a party. If that Mr. Tagum and Madam is saying, make the administrative reform a party. Hertz, Sri C. Modi, Learned Council for the petitioners. Also heard Sri S. Tagum, Learned Standing Council, Health Department.
Yes, my lord.
And Ms. So Learned State Council appearing for the Finance Department.
1, 2, 3, 4, 6, and 7.
3, 4, 6, and 7. Better. The Learned Council for the respondents have, however, raised the issue that the Administrative Reforms Department is a necessary party, which, however, has not been added as a party respondent. Para. Do Sri Modi, the Learned Council.
T-zone, my lord. T-zone.
So, sorry.
Not Modi.
Those is shown, Learned Council for the petitioners had initially submitted that response number 7 would cover the state department, subsequently he has submitted that an implement application would be filed.
Yes.
Shortly to implement the state department as a party respondent. In view of the aforesaid submission, the matter is adjourned by 1 week.
Yeah, 1
week to enable filing of such implement application.
Much obliged.
Yes.
My lord, I am for the petitioner. The last order was granted by this honorable court for dusty service.
Upon?
Accordingly, upon the respondent number 456.
226.
2 is the office at Maharashtra, and 3 is the MDA. And accordingly, this,
You have filed affidavit. You have filed affidavit
yes,
after such justice service.
that's the service that we have filed
Now,
affidavit.
have you filed affidavit thereafter in compliance?
Yes, my lord.
When did you file affidavit?
Okay, I'll-
Yes, you are appearing for whom, Mr. Kato?
My lord, I am for the respondent number one, my lord. Respondent number one has nothing to do with, my lord. The other respondent has, my lord, is the main, my lord, party.
Sorry, my lord, that we have filed only, given the justice service. We have,
No, you have also filed
So-
an affidavit. We have found an affidavit here. You have filed the affidavit on 24th of March 2025 by one Regam Nabam. Heard Sri so and so learned counsel for the petitioners, the petitioner, one petitioner who has submitted that this court wide order dated three 2025 had permitted serving of notice upon the respondent numbers 226 by Dusty and thereafter file affidavit as proof of such service para. In compliance of the aforesaid order, Dusty service has been effected, and in this regard, an affidavit has also been filed on 24 on 24/3/2025, full stop, perused the said affidavit, full stop. Upon perusal of the same and noting that the notices were indeed served upon the aforesaid respondents, service upon the respondent numbers 2/026 is deemed to be complete. Para, list after I have filed your affidavit.
No, my lord. Affidavit may not be.
3 M. Kato, learned Deputy SGI, has however submitted that though he is appearing for the respondent number 1, the impugned decision is taken by the respondent number 2, and therefore affidavit by the respondent number 1 may not be necessary. Para? In view of the above and in the interest of justice, the matter is adjourned by 4 weeks to enable the respondent numbers 226 to file affidavit if so advised.
okay.
28, yes, Mr. Lampu?
May I please, Lords. My lord, in this case, my lord, notice is yet to be issued, my lord. And what happened on, my lord, 17th March, my lord, when this
Notice
matter.
has not been issued.
Yes, my lord. On 17th March, my lord, when this matter has been moved, my lord, the learned Islamic Council for the Power Department has pointed out that tender, my lord, the award has, my lord, the award has been given to one farm, my lord. Therefore, he.
You have implemented this new
Yes, yes.
enterprise. You have implemented.
Yes, ma'am.
When was it done?
It was done on, my lord.
IA has orders have been passed in the IA.
Yes, my lord. It was passed on 29th April 2025, Lord. I was allowed on
Okay,
29th
I will
April.
issue notice in this. Okay. Heard Sri H. Lampu, learned counsel for the petitioner, who by means of this application has put to challenge an NIT dated 27/2/2025 issued by the SEPA Electrical Division, Arunachal Pradesh. Full stop. One of the main grounds of challenge is that the NIT was not issued electronically, which was the requirement of a notification dated 24/9/2019. Full stop. The said issue was, however, taken up for consideration by this court on 17/3/2025, when Sri Parme, the Learned Standing Council Power Department, had submitted that as per a subsequent notification dated 19/9/2020, hard copy was also allowed to be published, and had also informed this court that that one party was already allotted the work. Full stop. Subsequently, the petitioner had filed IA 13 AP 2025 for implement of the said party as party respondent, which was accordingly allowed by this court on 29/4/2025. Para? Let notice be issued. Returnable by 4 weeks. Three, your name?
On behalf of El Parme.
Sri so-and-so Learned Council appearing on instruction of Sri Parme, Learned Standing Council, Power Department.
Yes.
Accepts notice on behalf of respondents 1, 2, 3,
One, two,
and
and
1, 2, and 3. Let extra copies of the writ petition be served upon him by 2 working days. Let steps be taken for service of notice upon the respondent 4 by registered post to JD. Steps within 2 working days. List after 4 weeks for service report. এরকমটা এই যে হেরিটো আসলে আরম্ভ হচ্ছে আসলে মিস্টার ডোলে item Mr. Dole, yours item 4.
Yes, fine.
Yes, please come.
May I please?
Yes, please go
May I
ahead.
please, my lord? My lord, the petitioner's insistence, my lord, they were enjoying a plot of land, my lord, around, they were enjoying a possession of a plot of land, my lord.
Ancestors of the petitioner.
Yes, my lord.
How many of you are there?
My lord, here we are 5, my lord.
6 petitioners.
Yes, my lord. A Dhirang, my lord. It was around 10.15 acres, my lord.
10.15
acres.
Okay, then what happened?
Now, my lord, after the Chinese aggression, my lord, the 1962 war, my lord, the Indian army started coming, my lord, and they started to occupy our land, my lord. Now, we have objected to that, my lord, saying that we will not. However, my lord, they made us understood that it will be only on temporary basis, my lord. So they will not be taking it permanently, my lord. Thereafter, my lord, there was an understanding between the Indian army and the petitioners and sisters, my lord. And then, my lord, the land was taken on higher basis, my lord.
The piece of land which is the subject.
Yes,
matter,
my lord, the subject matter,
It
my
was
lord.
taken on hire,
Higher basis, my lord.
monthly rent or what?
A higher, 180 rupees per annum, my lord, per acre, my lord.
Okay.
So it was going on, my lord, and then they were paying the rent, my lord. Now cut to 2000, now 2000, my lord. The army left, my lord. But even then they were paying the rent, my lord.
2012,
Yeah,
army left.
till I think 1996, 85 to 1990, they started leaving one by one. They started leaving, but all by 2015, they all left, my lord. However, they were paying the rent, my lord, till 2016, my lord. The higher rent, my lord.
Yes.
Now thereafter, my lord, all of a sudden, my lord, the 30th battalion of SSB took possession of the land, my lord. Now, before that, my lord, in 2013, my lord, since the higher rate was very meager, my lord, it was 180 rupees per acre, my lord, per annum, my lord. So we had returned to the defense state officer, my lord, Tejpur, to acquire the land. Since the higher rate was very minimal, my lord. However, that was not taken into account, my lord. And we have even thereafter, my lord, after the occupation of the SSB, my lord, we have submitted representation to the commandant SSB and the concerned administrative officers, my lord, to the deputy commissioner and the ADC, my lord. But no action whatsoever was taken, my lord.
Yes.
Now, my only contention is that, my lord. Now, see, my lord, the army, we had an understanding with the army. Now, army has left, my lord, and we had an agreement with the army, my lord. And army comes under the defense, the Ministry of Defense, my lord. Now, SSB, being a paramilitary force, my lord, it comes under the Ministry of Home, my lord. So, since we have an understanding with the Ministry of Defense, my lord, how could the SSB take over the claim, my lord, the portion of that particular lane, my lord?
Okay.
Our humble prayer is that, my lord, since they have not, they don't have any right to take over the land, my lord. It is a private land, and there is no dispute from the army as per their affidavit, my lord, that we are not the owners, my lord. There is no dispute on that, my lord. And there is no dispute that there was not any agreement. And there is no dispute that they have left. And there is no dispute as such from the army that the rent was paid till 2016, my lord. All that we want is that, my lord, since it is our private land, my lord, that has to be, we have to be properly compensated, my lord. And the direction should be given to the concerned authorities, my lord, to acquire the land and give us the compensation, my lord, adequate compensation as for the new act, my lord. That is all that we are
Now,
asking.
what is the rent which is being paid to you?
180 rupees per. Now, after 2016, we have not been paid, my lord. But the SSB is taken over, my lord. Illegally, my lord. And thereafter, my lord, initially, my lord, the total land that we were, it was 10.15 acres, my lord. Now, after the possession, my lord, slowly the SSB is again encroached upon another 1.5 acres of land, my lord. So we have returned to the district administration, my lord, but no action whatsoever has been taken, my lord.
Yes.
If my lord come to page 38, my lord.
38.
38, my lord. And actually 2, my lord. Now, this is the letter written to the deputy commissioner by the assistant military state officer, my lord, dated June 1983, my lord. Now, my lord, I'm concerned with para 3, my lord. May I read it, my lord?
Yes, please.
Another area measuring 20.375 acres adjoining the above was hired on 3/9/1968. Out of 20.375 acres, an area measuring 10.15 acres is private land. This is my land, my lord, which was hired by the army, my lord.
Yes.
And the balance 10.255 acres is a government land. I'm concerned with 10.15 acres of land, my lord. The army has acknowledged that, my lord, it is a private land which was taken from us and then it was taken on hire basis, my lord. Next page, my lord, 39, 40 and 41, my lord, is the hire rent, my lord. My lord, turn to page 41, my lord. 41 is the last.
Yes.
Per acre per annum, 180 rupees, my lord. 4 people, my lord. It was, as per this document, my lord, we were paid till 31/12/2015, my lord. But I've been informed that it was paid till 2016, my lord. But I have not annexed the document, my lord. Now, thereafter, my lord, I have written and I will not burden my lord with all the representations, my lord. Now, my lord, similarly, my lord, in the same case, my lord, if my lord turn to page 54, my lord. 54, my lord. This is an order passed by this honorable court, my lord. Page 54, 54, my lord.
WPC.
Yes, my lord, 390. Now, the issue here is same, my lord. Here, the army has taken over the land and they occupied it, and the petitioners, they have prayed for acquiring the land with adequate compensation and acquiring the land under the new act, my lord. The only difference here is that, my lord, in our case, my lord, the army has taken over the land on hire basis, my lord. Here, there was no hire basis. They have just occupied it, my lord. That was the only issue. But since now the army has left, my lord, after paying the hire rent till 2016, now since the SSB has taken over the land without illegally, without the permission of the landowners, my lord, I'll just read the operative part, my lord.
But can we give a direction for them to acquire? It is up to them whether they need the land or.
I'm not into that. My lord is absolutely right, my lord. But at least since they are occupying our land, let them pay
So far as your prayer for fair
compensation.
rent is concerned, that is a very bona fide prayer, subject to what we hear from Mr. Doloi.
No, they have only left, and it is on,
But
on records.
the prayer which appears from the direction in the earlier case,
my lord,
the directing for acquiring the land, that perhaps would not be a fair thing, because it is for them to decide
my lord,
whether they need this land on a permanent basis or not. To acquire or not to acquire, they have to give the
my lord. That I understand, my lord.
The requisition they have to give to the district administration, which will be done.
My lord.
But that is up to them. But so far as utilizing your land is concerned, there is no ambiguity or any dispute that you are entitled to a fair
compensation,
fair compensation, either in the form of a requisition compensation or acquisition compensation, whatever. If it's a requisition compensation, rent has to be fairly determined and paid.
But it will be subject to what if the owners accept to it, my lord.
No, it has to be determined.
Yeah.
You have the avenue to be aggrieved by the amount also.
My lord, my lord.
That's why you can raise the grievance.
That is enough, my lord. If they give us adequate
but
compensation.
If you are saying that from 2016, nothing has been paid at all.
My lord.
That is one part which Mr. Doloil has to explain.
Yes.
Number two, what is the compensation they are contemplating to pay as rent?
My lord.
And we also need the state's assistance.
The state, I think, my lord, here there are 3 parties, my lord. My elder brother, Mr. Dola, is appearing for the army, my lord. And for the SSB, I think Mr. Kato is appearing, my lord.
Oh, for SSB, Mr. Kato?
Yes, my lord. And their statement in the affidavit are different, my lord. Now, they are not, the army is not disputing, my lord. the ownership, the land.
No,
the
Mr.
rent-
Pada, what we have understood from your submissions
My
that
lord.
your present grievance is not per se against the army, you are
My lord.
against the SSB.
My lord,
To determine a fair compensation paid to you.
my lord.
And the aspect of 2016 arrears would also come. Arrears from 2016
That
onwards.
is what I'm praying for, my lord.
Yes.
Yes, I am appear from under respondent for 6 and 7. And we have taken the land, we have already paid the rent, my lord. Now grievances are not against us. We have vacated the land, we have returned to the landowners.
You're from
Subsequent
Mr. Dolo for 6 and
6
7.
and 7, my lord.
Okay.
6 and 7, we have already paid the rent that your, my affidavit in opposition, last and next I will find it. Up to that rent was paid and land was given back to the landowners, my lord. Now it is up to the respondent 1 and 5, whether this SSB has taken or not. This is respondent number 1 for 5. To list that.
No, see, your ministry may be different, but
Yes,
you are a
yes.
part of the Union of India. So
Absolutely.
we don't see you in a different entity.
Yes, yes, yes.
There has to be a synchrony between you. You cannot take one stand which is being
Yes,
disputed by Mr. Kato. Neither will allow Mr. Kato to take a stand which is disputed by another ministry. Ministries are all a part of the Union of India.
Yes.
So, Mr. Kato, your stand has to be consistent with the stand of the army.
No, my lord. Therefore, my lord, time and again, I written a letter to the, my lord, the authorities concerned.
Which
Why-
authority?
My lord, the authorities, the Ministry of Defense, my lord. And my lord, the Ministry of Defense and my lord, the DO. DO, role of the, my lord, DO Tezpuri is to, my lord, locate. And my lord, the two, my lord, lies with the administration, district administration. So therefore, my lord, there are so many instances where my lord, the Union of India is taking different stands and the other, my lord, the local military.
You
authorities.
cannot speak in two voices.
Yes,
You are
ma'am.
part of the government
So let the-
and you are the deputy HGI. You cannot make this kind
No,
of
my lord.
submission. We're not,
Man,
not
here the
accept
man
it.
of the defense, man of the have no role to play. Man of the Mr. Dolo is appearing on behalf of the Union of India. Man, it has been special permission from the Ministry of Calcutta. Man, because of that reason, time.
No, if Mr. Dolo says that I am not only representing the army but the Union of India as a whole.
Yes, yes,
Then we'll
absolutely.
ask Mr. Dolo to have it matter resolved.
Yes, madam.
Yes, yes.
Therefore, madam.
Yes.
Exactly, madam. This is not only in this case, madam. In so many cases, madam, such situations are coming up.
No, it doesn't look good. It doesn't look good at all. You
Yes.
cannot speak in two voices. You are part of the government, you're part of the
Yes,
union.
madam. Time and again, madam, if lordship perused the madam, several letters, madam, issued to the madam, the concerned authorities. This is not the only cases where, madam, the departments are taking different steps. Madam, they come under the Ministry of Defense. It is duty on the part of the Ministry of Defense to, madam, to look after the entire thing. Now they are coming with different affidavit. Now the madam, SSB is coming with different affidavits. madam.
They're totally contracting.
Therefore, madam,
No, in my.
it will be a better position if the DO along with the SSB or along with any other organization comes under the Ministry of Defense. They sit together and work out the matter. Then the matter will be resolved. Madam. So therefore, madam, time and again, madam, as lordship has already pointed out, madam, that madam, difficulty I am facing is that is the only whole thing, madam.
In this case, my lord,
Madam, not only in this case, other cases also, madam,
No, I-
situation are coming up, madam.
No, other cases will deal.
no,
when
no,
the
I am
matter
talking
comes
about
up.
this case. This case, I am appealing for respondent number 6 and 7. We have taken the land. Then after the 2016, army has vacated the land. And land was given back to the landowners with the rent.
It was not given to us. The rent was paid, but then.
Rent was
they
given.
let it go.
So that is that we have stated in our paragraph number, your lordship may see, para 16 of my
You
affidavit.
filed affidavit opposition when?
Yes, yes. It was filed on 5th of November, my lord.
September.
Which year?
24. 05092024. My affidavit was filed.
September.
No, September. 24 September.
5th of September.
5th September.
5th September, yes.
5/9.
5th and 9.
Okay.
Here we have stated in paragraph, para 6, my lord, page 16. We have made our stand clear.
Page?
Page 16, para 6, page 16.
Just a minute, please. Yes.
Has your lordship?
Yes, please.
The para 6, my lord, that with regard to the statement made in paragraph so and so, written in answering the opponent basis that based on the headquarter 51 commander zone sub area, white number so and so dated 6/07/67, and the amendment letter number so and so, accorded administrative sanction for hiring requisition of the land measure 20.375 areas, that is 10.150 acres as developed land and 10.225 acres as barren land in village of Young District Circle. The lease agreement pertains to the land measuring 10.150 acres of the Young village was signed between the landowners and DO Tazpur on 30/11/1973 in presence of the circle officer Dirang, Kameng District, NEFA, and the lease rent for the measuring 10.150 acres was paid to the landowners till year 2016. The petitioner accepted and received the lease rent without any objection on any amount of release. Then subsequently, my lord, another SSB has come. The next time we have made it clear at page 20, para 15.
Page 20.
Page 20, para 15, my lord.
Yes.
Respondent authority number 6 and 7 did not encroach any land of the petitioners. Rather, the land of the petitioner was held by the army on hiring basis, for which rental was paid to the petitioner from time to time till 2016. So this is the, and last page, your lordship may see, page 51, annexure 6.
Page 52.
Page 51 and 52.
Yes.
The page 152, these are the land area or acres, the name of the owners, rent per was fixed, the rent from 01/01/2006 to this is paid, this is 364.50, and subsequently 1462.50 to tell 1,828. Next page also, these are the landowners, my lord, and total area, total amount 1828 up to 31/12/2016, we have paid and vacated the land.
Yes.
That is my stand as a respondent number 6 and 7. So after that, Mr. Kato will reply what happened to 1 to 5. He is appealing for 1 to 5. He has filed.
No,
an
Mr. Kato has already said that his communications.
Yes.
No, my lord, they have filed a affidavit.
They have filed affidavit.
It is on record, my lord.
We are not saying he has not filed it. Kindly listen to the court.
My lord.
He said that in the affidavit, he is not asking a communication to his client. He's saying that his client has made communications to the defense ministry,
Yes.
which were not responded to. And therefore, he is in a fix. What stand to take? He is not disputing
Yes.
that he is
My
in
lord.
possession of the land.
So as well as behind me, DO also present with me now. My lord, if your lordship desires him, you may
No,
put
not
with-
necessary. If it is the requirement, we'll call him. Not
Yes.
necessary, why should he come? So what do you, yes, Mr. Kato, what do you say? How do you resolve this?
Categorically, we have stated in our affidavit filed by the mother. Commanding mother on behalf of respondent number 1, madam.
You filed on 23rd of April.
Correct. Para 4, page number 54, madam. The answer in the phone.
Just a minute. Yes.
Married from Malad the Para 4. The answer in the phone. Answer in the phone respective summits that approximately 10 acres of forest land, which is located below the main road beyond Kompa, was originally earmarked and allotted to first BLGC Dhiran,
Mm.
Arunachal Pradesh, by the then the Chief Commissioner of Arunachal Pradesh during his visit in 21st BN by Deputy Commissioner to notes coming the notes coming district 16 to 23 March 1975 annexure 1. Accordingly, first BN SSP Iran has requested to a divisional forest officer Bomdila coming district Arunachal Pradesh to hand over the lands to the SSP by letter number so and so 28 July 1975 annexure 2 man. In reply, Divisional Forest Officer Tawang, Forest Division, Bomdila has intimated to this unit that you may take over the appropriate area for raising apple plant by number so and so, dated 9 September 1975. Annexure 3.
This was in the communication where of the year 1975.
Correct.
But army was there till 2016.
Well, that will be clarified by them only.
No, they have said 2016 till 2016, rent has been paid.
Yes, my lord. But then army, we entered into an agreement in 1968, my lord.
No, that is okay. We are not on that. We are on the post 2016
My lord.
period.
My lord.
You said that in 2016, though the army started living in 2012, till 16 the rent has been paid.
My lord.
So therefore, my lord, this land has been very much allotted to the Malad in the year 1975. By that, and earlier, my lord.
Now, where is your statement that when you had come into the picture? When?
Malad, that has been Malad allotted by the Malad earlier. Malad, the allotment was given by the commissioner, chief commissioner. Malad. Now these days, Malad district administration.
Now, when have you come to the picture? When did you take possession of the land?
Malad possession at that year, Malad itself. Malad.
Which year?
1975.
75.
Malad. It was allotted in the year Malad. As per that, there is no Malad particular Malad statement.
But why was the army paying, the defense ministry paying till 2016? The projected case.
I'm sorry, Malad. That expect Malad. To that extent, Malad, there is
No,
no.
Mr. Kato, the projected case by the petitioner is that 62 on the army had come because of the aggression.
Malad.
And 62 onwards till 2016, army was in continuous position, though from 2012 onwards, they started moving out. 16, SSB had come in. But your communication says that as if from 1975,
Yes.
you came into the picture.
Right.
But where are you paying rent?
Malad, it is the Malad extent of the SSB that land has been given to the SSB for.
No, if you are given the land, what consideration did you make? Did you pay rent? Was it required for you?
Malad, may I present Malad, another Malad, the time will be granted, Malad. I'll come with that Malad. This is the Malad affidavit filed by the respondent number.
No, after the undisputed factual assertion by the petitioner, which even endorsed by Mr. Doloi, till 2016, the matter is, there is no dispute as such.
Yes, Malad.
Though he may be aggrieved by the amount involved, but he has not raised much of an issue so far as the amount is involved, whether it's small or whether it's big. He is more interested for the amount after 2016. First, he says that there is no agreement with you.
Yes.
So whether he'll agree upon 180 is a different matter altogether, per acre, per annum. Number two, if it's a rental thing, there has to be a fresh agreement. If you want to acquire it for a permanent basis, you have to go for an acquisition proceeding.
Therefore, Malad, in that Malad, if such is the position, Malad, may I present Malad? Malad, admittedly, respondent number 1 filed this affidavit, Malad, without Malad mentioning any other Malad relevant information, Malad. This is the only communications by which Malad the SSB has been authorized to occupy the land, Malad. But then Malad, there is no Malad to whisper about the Malad, any Malad. This affidavit has been filed by the ministry, Malad. Respondent number 1, Malad.
But in the affidavit of Mr. Doloi, he has not only led us to the pleadings in the affidavit, he has also led us to the chart of payment. The chart of payment is of a much recent date, page 51. That is an official document.
Malad, I'm not.
No, we are not burdening you till 2016.
Malad.
Even though you have shown us a letter of 75 that this land was given to you for apple cultivation or whatever, even the petitioner says that from 2016 onwards you had come.
Yes.
And so whether it come in a period prior to 16 will not cause any prejudice to you. It's not your case that we are not in possession. We want to resolve the issue by directing that sort out.
Well, if the direction is given to the deputy commissioner, whether they wanted to acquire it or not,
No, the deputy commissioner will not acquire unless there is a request from you.
correct me.
You have to say that, yes, we need
Yes,
this
yes.
land on permanent basis.
The requisition has to be initiated.
Or
by
if
the
you do
user.
not want, then at least the requisition amount has to be paid to them. Either you acquire or require. If you are requiring it, you pay the rent in accordance with law.
By this affidavit, clear extent of the SSBs, land has been given to them by the commissioner. Since 1975, it is under the position of the SSB.
Then if it is under the position of the SSB, there would be some document to show that you had made some payments either to the owners of the land, who is the petitioners, or to the state for acquiring or whatever. You cannot just acquire land. It has to be allotted to you. You are not a private party.
And there is no separate allotment order also. This is the only communications made during the tour time of the chief commission.
Mr. Pada, where is your statement that SSB came into the picture when?
Yes,
Which
my lord.
paragraph?
Yes, my lord.
You said the 30 battalion of SSB took position when?
Yes, my lord. I'll just. Oh. Paragraph 7, my lord.
Page
20,
Page 20, my lord.
20.
In paragraph 5 also, 6 also, my lord, but then I am not given the exact year on which.
Where have you stated that till 2016 the rent was paid?
My lord.
Or rather from 2016?
6, my lord.
Paragraph 6.
Yes, my lord.
Where?
Page 18, my lord. I have stated till 2015, my lord. That's because the document which was available with me was till 2015, my lord. But through the affidavit filed by the defense, my lord, this, I have come to know that it was paid till 16, my lord.
But Mr. Dolo, you are saying that you have been paying the rent
Yes.
till 2016.
16. Yes.
The contention of the petitioner is we are encroaching the land of the petitioner, not exactly Malad. Therefore, this is the correspondence which has been made to the Malad ITB, SSB.
Now, from the reading of the pleadings, it appears that from a long time, this transition period was going on. Army was living, he said, in one point of time in 2000 and 1990, we have seen somewhere. Yes, from Indian Army
85
in between 1985 to 19 had left the land. The vacation of the land was going on for a long period. It cannot be done in one day from till 90. But as per that is why you had asked a pertinent question, direct question to Mr. Doloi, that till what date or year the rent was being paid by the army. Said 2016.
Right.
Well, after 2016, the ties, if any, was severed of the army with the petitioners. And you had in the meantime come into the picture. Though the rent was paid by the army, maybe you had come in before then. But after 16, your liability to pay the rent has come. Okay, we'll dictate the order at 2 o'clock. And one more matter, perhaps. Which matter? Two matters. Kundu.
31 is.
Oh, your matter is also there. What is the matter?
Regarding army occupation. But subject matter is slightly different. But this matter will take time, my lord. I need more than 1 hour.
But we'll complete that matter, then we'll complete on
Yes,
that.
yes.
Okay. If you have the time, thereafter we'll have the.
Yes.
Page? Page.
63, madam. The typed copy would be page 65, madam.
Page 3.
Oh, sorry, my lord, before that, my lord, page 60, my lord.
60.
60, my lord.
Yes.
And typed copy, my lord, will find at page 61, my lord. My lord, this is a true note by the Kameng district on 16 to 23rd March 1975, my lord. Now, what they are purportedly saying that the lane was given to them, my lord, it was just a true note, by the then deputy commissioner, my lord, wherein he had promised that he will do his best to give the lane to the SSB, man.
Yes.
If my lord goes down below para 6, my lord, may read it, my lord, since it is not clear, my lord, may kindly turn to page 62, my lord.
Yes, type portion.
Yes, my lord.
Yes.
While visiting 21BN, SSB, the chief commissioner decided that approximately 10 acres of land below the main road, beyond the SSB Gompa, originally earmarked for forest plantation, would better and more usefully be preserved for soil conservation by handing it over to the SSB battalion for plantation of apple and other fruit trees. Orders to this effect were issued on the spot. The Commandant 21BN SSB would assist the forest department in making out any small sapling already planted here and replanting them at the other nearby locations. The area above the main road would continue to be put under forest plantation, my lord. I have an apprehension that, my lord, the land that they are talking about is a different land, my lord. Because it was clear from the affidavit filed by the army, my lord, that ours is a developed land, my lord. There is no plantation in there, my lord. And next page is the letter written by the chief secretary, my lord. But I'll directly go to the last page, my lord. Here, the divisional forest officer, he has given the handed over the land to the SSB, my lord.
Where? Page?
Page 67, my lord. No, my lord, page 68, my lord. With reference to your letter, cited number, I am to inform you that you may take over the appropriate area for raising apple plants as desired by the chief commissioner, Arunachal Pradesh. Since the seedlings.
Page you are reading? Page?
68, my lord, last page, my lord.
Yes.
Last page, man.
Yes.
With reference to your letter number cited above, I am to inform you that you may take over the apportioned area for raising apple plants as desired by the Chief Commissioner, Arunachal Pradesh. Since the seedlings planted there have already been established, and since plant mortality will be much more if it is not legible, my lord, them and replant them now in some other place, the same may be left as such if it is not objectionable to your objective. It seems that the deputy commissioner, the DFO has handed over the land. But purportedly, I believe that, my lord, this is a different land now.
Yes.
And my lord, since my lord, they have illegally occupied my land, my lord, after the RB have led, my lord, after 2016, my lord. There's a small citation which, my lord, I need to place, my lord. My lord, 2022 SSC 569.
Name?
Vindhya Devi,
Meera Devi.
Vidya Devi,
Divya Devi.
Vidya,
Vidya. How do you spell it? V.
Vidya. The land of this old lady, an illiterate lady, was taken over by the government, the state government, in the 1967-68, my lord, for construction of the road, my lord. Thereafter, my lord, she came to know the similarly situated persons, my lord. In 2004, my lord, they applied for compensation and they were given adequate compensation, my lord. May I directly come to the operative part, my lord? There are 2.1, 12.1, my lord. Page number 527. 572.
Yes.
The appellant was forcefully expropriated for her property of her property in 1967, where the right of property was a fundamental right guaranteed by Article 31 in the Part 3 of the Constitution. Article 31 guaranteed the right of private property, which could not be deprived without due process of law and upon just and proper compensation. The right to property ceased to be a fundamental right by the Constitution, 14th Amendment Act 1978. However, it continues to be a human right in a welfare state and constitutional right under Article 300A of the Constitution. Article 300A provides that no person shall be deprived of his property save by authority of law. The state cannot disposes a citizen of his property except in accordance with the procedure established by law. The obligation to pay compensation, though not expressly included in Article 300A, can be inferred in that article. To forcefully disposes a person of his private property without following due process of law would be violative of a human right. That's also the constitutional right under Article 300A of the Constitution. Reliance is placed on the judgment of so and so, so and so. Having regard to the provision contained in Article 300A of the Constitution, the state is in exercise of its power of eminent domain may interfere with the right of the property of a person by acquiring the same, but the same must be for a public purpose and reasonable compensation must be paid. Now, next paragraph, my lord. Right, the same cannot be taken away except in accordance with law. Article 300A of the Constitution protects such right. The provisions of the acts seeking to divest such right, keeping in view of the provisions of Article 300A of the Constitution of India, must be strictly construed. In so and so versus so and so, it is accepted in every jurisprudence and by different political thinkers that some amount of property right is an indispensable safeguard against tyranny and economic oppression of the government. Jefferson was of the view that liberty cannot long subsist without the support of property. Property must be secure, else liberty cannot subsist, was the opinion of John Adams. Indeed, the view that property itself is the seedbed which must be conserved if other constitutional values are to be flourished, is the consensus among political thinkers of the jurist. In other words, Article 300A only limits the power of the state that no person shall be deprived of his property save by authority of law. There has to be no deprivation without any sanction of law. Deprivation by any other mode is not acquisition or taking possession under Article 300A. In other words, if there is no law, there is no deprivation. In this case, the appellant could not have been forcefully dispossessed of her property without any legal sanction and without following due process of law, and depriving her payment of just compensation being a fundamental right on the death of forcible dispossession in 1968, my lord. Under the same principle, my lord, they have taken over the possession of my land, my lord, without any authority of law, my lord. So what I am seeking for and praying for is that, my lord, a legal right to have a just compensation, my lord. There is only from 2016, my lord, since the army have left and
Response numbers 9 and 10,
Page.
Your Lordship. Page 5. Page 5, Your Lordship. Paragraph 12. Married, Your Lordship. That with regards to
Just a minute, paragraph, page 5.
5, Your Lordship.
Paragraph 10, paragraph 12.
12, Your Lordship.
12.
12.
Okay.
That with regards to the statement made in paragraph 21 of the writ petition, the answering response begs to state that the respondent number 1 to 7 never made any representation to the answering respondent for acquisition of land which they are claiming to possess. Moreover, both the petitioners and respondent number 1 to 7 are disputing the title over the land in question. Therefore, the allegation made by the petitioner against the answering respondent is based. Your Lordship, since the main case is that title or ownership of the land is in question, Your Lordship. Your Lordship. Otherwise, Your Lordship, they can go for the appeal.
No, who is questioning?
Yes, Your Lordship.
Who is questioning the title or ownership?
The petitioner and the respondent number 1 to 7.
Who has questioned? Tell us. It becomes a disputed question of fact when there is a dispute raised. Has anyone said that they are not the owners?
Yes, Your Lordship.
Has anyone said that they are not the owners?
The petitioner, they are claiming that they are the owner.
Where is the dispute? Who is saying that they are not the owner? To constitute a dispute of facts, there has to be a denial of facts. Where is the
Yes.
denial?
Otherwise, also, Your Lordship, there is no letter for the acquisition of the land, Your Lordship. If we receive any acquisition representation.
No,
for
that's a different,
acquisition-
we are on a different facet. We are not on the facet of receiving any requirement for acquisition. You had raised the question of going to the civil court to assert their rights. It has to be a disputed question of fact. Their claim for ownership. If it is a disputed question, you have to show us from the pleadings that their claim for ownership is disputed on.
It is given in our affidavit only. Your
Where?
Lordship.
Show us.
The answering respondent begs to paragraph, yes, our paragraph 9. Received by office of the DC, Bomdila, West Kamen District, but the issue and subject matter of the land dispute is between the petitioners and the respondent number 1 to 7. And the title over the said land is main dispute between the petitioners and respondent 1 to 7. Your Lordship.
1 to 7, are they claiming the ownership?
Therefore, the question of land equation does not, it is given like that.
See, in a given case, yes, if their basic claim, which they are making on the basis of certain pleadings, are disputed in another affidavit, then your question, your issue, the point which you are trying to raise would be a valid point, but may not be in this case. Okay.
Madam, in addition to my submission, madam, though it is on madam, the affidavit, but madam, apart from that, madam, there is no specific madam, the environment, the particulars of which madam, the land of the SSB is encroaching, man. Only that extent, the petitioner is claiming ownership over the lane, which has already been handed over, which has already been in possessions of the of
Paragraph 7, page 20.
yes, madam.
Please read.
The petitioner begs to state that after vacations of the land by the Indian Army, the 30th BNSSB illegally took over the land, madam. This is the only specific matter. Therefore, madam, we are denying, madam. Considerably, after passage of time, the 30 BNSSB, they gradually started further enforcements of the private land of the petitioners. Thus, being aggrieved of the act of the so and so, the petitioners on several occasions had submitted representations before the district administration, and partly on so and so, the petitioner had again submitted the representations before the additional deputy commissioner, Dirang Western districts by requesting for immediate interference and necessary actions to vacate the. Their basic contention is we are encroaching the land of the.
Mr. Kato, before you make any submission, can you come to your affidavit? What is your reply to this?
Yes, madam. My affidavit to that extent, my lord, the land under the positions of the SSB has been duly allotted, my lord.
No, come to the your reply to paragraph 7. Paragraph 7, they have made a categorical statement that the petitioner begs to state that after vacation of the land by the Indian Army, 30 battalion SSB illegally took over the land. What have you stated?
No, my lord, in that aspect.
What have you stated? Let us see your page.
Yes, madam. Page 55.
55, paragraph 8.
55, para 8, madam.
Please read.
With regard to the statement made in paragraph 7 of the writ petitions, the answering deponent offers no comments.
No comments. You are not even denying. Not even talking about evasive denial. You are not even denying. Not even an evasive denial.
If we again peruse the paragraph 7 again,
yes,
there is no specific which part of the land has been encroached by the petitioner, sorry, SSB.
That is not the answer. That is not the question even they have raised.
It is which portions of land, how much of areas has been encroached by the SSB?
That have been clarified by the army itself.
There is a, I think
even no specific location, paragraph, and any other things has been specifically mentioned in paragraph 7 for which which particular floor land has been pointed out by the petitioner, So therefore, there's which particular level, where, which location, and the area of land is also not categorically mentioned for which the detailed environment is required to be made in reply of this paragraph. So therefore, simply the army, the SSP authorities has given that no, this requires no the further comments is because this is not a specific environment by which the required detailed environment has to be made. And in fact, the SSB is occupying vast area in the said location.
They are concerned with 10.15 acres.
155 acres.
10.15.
But admittedly, as per the affidavit, 10 acres of land has been under the occupations of the SSB.
Yes.
Out of 10, it means if 11, only 1 acre is under the allegation of the enforcement.
He's not getting it right.
We'll come to you, Mr. Further. Come to page 38.
Page 38, it is
by the army authorities. How much was the area?
Page 38, para.
Page 38, annexure 2. $10.150 acres is private land.
Admittedly, the SSB is under the occupation of vast area, So out of which portion of land, the petitioner is also not categorically making the that statement.
No, see, 7, you cannot read in isolation. 7 is, you have to read along with 6. In 6 days, the army, Indian army in between 1985 to 1980 had left.
It seems that they are also not sure about their
Eventually,
land.
after vacating the land, asserting the position after vacating the no authority to so and so, thereafter, the vacation of the land, authorities to illegally took over the land. It is the same land they are talking about. Land has been described.
In response to para 6, the authority is reiterating the statement made in para 2, and para 2 of the affidavit is important. I'm sorry, it must be para 4, May I read para 4 again,
Yes, para 4 of?
My affidavit,
Yes, please read.
The answering deponent respectfully submits that approximately 10 acres of forest land, which is located below the main road beyond Gompa, was originally earmarked and allotted to 21st GC Dirang, Arunachal Pradesh, by the then Chief Commissioner of Arunachal Pradesh during his visit in 21st BN by Deputy Commissioner to notes that so and so dated March annexure government. Accordingly, the first BN Dirang was requested to Divisional Forest Bomdila Arunachal Pradesh to hand over the land to SSB by letter number so and so 28 July 1975. In reply, Divisional Forest, I'm reading again, Forest Division, Bomdila has intimated to this unit that you may take over this said area for raising apple plant by number so and so dated so and so 9 September 1975.
Yes.
So therefore, this is under the occupations of the authorities, as per the earmark given by the then Chief Commissioner. Admittedly, to that extent, how much of area has been duly allotted to the SSP has not been enclosed in this the affidavit.
We are not directing you to pay compensation for areas which is not under your possession. The direction will only be the area of the petitioner where you are occupying. It may be 10 acres, it may be 9 acres, it may be 11 acres. We cannot determine.
Direction for the verification or the to that extent.
Obviously, there we are not a fact finding. We don't have the mechanism, expertise to do a fact finding exercise.
Once the re-verification process is initiated along in presence of the SSB, everything will be clear. What they are submitting is they are under the occupations of said lane on being allotted by the competent authorities. That is the statement.
Yes. The instant writ petition has been filed with the following prayer, page 32. It is the projected case of the petitioners is that in the year 1965, the Indian Army had forcefully occupied the land of the petitioners, which measures more than 10 acres at Dirang in the West Kameng district in the state of Arunachal Pradesh. Full stop. Though such occupation was objected to, the said objections were not paid any heed to. Full stop. It is, however, the case of the petitioners that such occupation was done during the time of their predecessors, and an understanding was arrived at that certain higher charge would be paid by the Indian Army. Full stop. It has been projected that as per the said understanding, the higher charge was paid, which was also of a meager amount of rupees 180 per annum per acre. Full stop. However, from the period of 1985 to 1990, the Indian Army was gradually vacating the land, and thereafter the Sashastra Sima Bal within bracket SSB had started occupying the land, which was without the consent of the petitioners. Full stop. It is also averred that apart from the apart from the aforesaid land, another additional land of 1.5 acres have been occupied by the SSB. Full stop. It is the case of the petitioner that though the Indian Army had vacated the land, the higher charge was paid till the year 2016. And though in the meantime, the possession was taken over by the SSB, nothing has been paid till now. Full stop. Word that the petitioners had approached the district administration, which was of no avail. And finally, the instant writ petition has been filed for adequate relief. Now, for the relief as indicated above, para, I have heard Sri O. Pada, learned counsel for the petitioners. I have also heard Sri one, two. No, Mr. Doloy is for?
For 6 and 7.
I've also heard Sri M. Kato, learned deputy SGI for the respondents 1 to 5. Whereas Sri Y. Doloy, learned, you appear as CGC.
Yes, senior panel counsel for
Learned senior panel counsel for Union of India, appears for respondent 6 and 7. Ms. Sangeeta for?
Yes, Your Worship.
Learned State Council is present for the respond numbers 8 and 9.
8, 9, and 10.
8, 9, and 10. Para. Sri Pada, the learned counsel for the petitioners, has submitted that during the period when the land in question was in the possession of the Indian Army, the higher charge, as noted above, was paid, and such payment continued till the year 2016. Full stop. However, after taking over possession by the SSB, which was also illegally done, nothing has been paid, and the petitioners have also not consented for taking over such possession. Full stop. In this regard, the learned counsel for the petitioners has drawn the attention of this court to the averments made in paragraph 6 and 7 of the writ petition, and has contended that though initially the land under the occupation was about 10 acres, subsequently 1.5 acres have also been encroached by the SSB. Full stop. He has also referred to the communication dated of June 1983 by the Assistant Military Estates Officer Tejpur, to the Deputy Commissioner of the district from where it appears that the private land involved is of 10.150 acres. And it is this land which belongs to the petitioners and is the subject matter of this writ petition, full stop. He has also referred to the statement of rental compensation, which is countersigned by the additional deputy commissioner, in which not only the rate but also the amount involved for certain periods have been stated, full stop. He has submitted that it is not in dispute that till the year 2016, the rent in question was paid and received by the petitioners, full stop. The learned counsel has also relied upon an order dated 2/3/2016. Where is that order? Passed by this court in WPC 390 of 2015.
Page 54, my lord. Page 54,
54.
my lord.
Yes.
Annexure
Yes.
11.
54. In which this court in a similar matter had directed the authorities to acquire the land in question as per the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. If they deem it fit, or the authorities would have to vacate the land in occupation on payment of reasonable compensation for the period of occupation is concerned. The learned counsel for the petitioners has also relied upon the case of Vidya Devi versus State of Himachal Pradesh and others, reported in 2020, 2 SCC 569, in which the Honorable Supreme Court has elaborately discussed the right of a citizen on property, which was in the Constitution before its amendment in the year 1978. Full stop. It has been clarified that though after the said amendment, Article 31 has been repealed, the said right continues to be a human right in a welfare state and is a constitutional right under Article 300A. The learned counsel accordingly submits that appropriate directions be issued either to acquire the said land in accordance with law and pay the due compensation, or otherwise vacate the land after payment of the requisition compensation at a reasonable rate. Para 3. Kato, the learned Deputy GI, by referring to the affidavit in opposition filed on 23/4/2025, has submitted that the land in question was allotted to the 21st Battalion of the SSB way back, which is discernible from the TOR note, TOUR note of 16th to 23rd March 1975 as annexed in the as would appear from the records, full stop. It is submitted that vast areas of land are under the possession of the SSB, and without there being specification of the land in question, the present claim may not even be maintainable. He has also submitted that the land that the land was originally possessed by the Indian Army, for which the requisite rent has already been paid, and there may not be any liability of the SSB as such. Para. 3. Doloi, the learned counsel, appearing for the response number 6 and 7, has referred to the affidavit in opposition filed on 5/9/2024 and has clarified that there is no grievance of the petitioners against the army as such. Full stop. He has drawn the attention of this court to the averments made in paragraph 6 and 15 of the affidavit, which are extracted herein below. Full stop. He has also drawn the attention of this court to the chart whereby the payments made, whereby the details of the payments made have been elaborately stated. Full stop. The learned counsel has submitted that it is up to the court to pass appropriate orders in accordance with law. Para. Ms. Sangeeta.
Next, rent agreement also.
Sri Doloi, the learned counsel, has also referred to the rent agreement which was entered into by the army with the predecessors of the petitioners pertaining to the land in question. Full stop. Sri Sangeeta, the learned state counsel, has submitted that the respondent numbers 1 to 7 had never made any representation for acquiring the land, and in this regard, she has referred to the averments made in paragraph 12 of the affidavit filed by the respondent number 9, dated, what is the date, madam? Which page?
24, 2022.
Which page is your affidavit?
The affidavit. 5, Your Lordship, affidavit. Page number 5.
Page number
5.
5 of the affidavit filed on 5. No, 6 and 7. No. What is your name? Oh, page 5.
Affidavit filed on 18th.
Dated, we went to date. Date is 26/4/2022, correct?
Yes.
She has also raised the issue that disputed questions of fact, that the instant proceeding consists of disputed questions of facts which may not be able to be addressed by this court. Para. The rival contentions have been duly considered and the materials placed on record have been carefully examined. Para. As per the facts projected, after the Chinese aggression in the year 1962, the Indian Army, there was a requirement for the Indian Army to station itself at strategic locations, and in this regard, the possession of the land in question was taken over. Full stop. Though it has been, though an impression has been given that such taking over was not with the consent of the predecessors of the petitioner, the exigency of the situation was perhaps the reason for such taking over, full stop. In any case, comma, such taking over is not the subject matter, and the learned counsel for the petitioners have also admitted that subsequently an understanding was arrived at, which also led to signing of a rent agreement for payment of a yearly rent for the area in question, full stop. It also appears from the records and is not in dispute that gradually the army had left the area, and according to the petitioners, the area in question was taken over possession by the 38th Battalion of the SSB, which was without any consent, full stop. It is also averred that though the army authorities had paid the rent till the year 2016, though it was a meager amount, comma, the SSB has not paid anything after 2016 in spite of utilizing the land, full stop. In this regard, the averments made in paragraph 7 of the writ petition is required to be noted, which is extracted herein below. Para. The case of the petitioner is that either the land is to be acquired by the SSB by payment of adequate compensation in accordance with law, including the requisition compensation till such date of such acquisition, or otherwise the land is required to be vacated and peaceful possession of the same be handed over to the petitioners. Para. In this regard, the opposition made on behalf of the SSB is liable to be taken into consideration. Full stop. It has been argued that though vast areas of land are in the possession of SSB, comma, it is not clear from the petition as to whether the land in question is actually under the possession of the SSB. Full stop. To examine the aforesaid issue, it would be required to note it is required to refer to the stand of the SSB in its affidavit in opposition filed on 23/4/2025 in reply to the averments made in paragraph 7 of the writ petition. Full stop. For ready reference, the reply to paragraph 7 of the writ petition, which is given in paragraph 8 of the affidavit in opposition, is extracted herein below, page 55, para 8, extract. From a reading of the aforesaid pleadings, comma, this court is of a firm opinion that there is no denial at all, not even an evasive denial on the facts projected, full stop. Para. That apart, comma, the affidavit filed by respondent number 6 and 7 would also has also been referred, which would also throw sufficient light on the issue involved, full stop. The pleadings of the said affidavit, relevant pleadings, the relevant pleadings of the said affidavit, which has been extracted above, would leave no room of doubt that it is the area in question which is in the possession of the SSB since the year 2016, full stop. The averments made that no rent or any compensation has been paid since 2016 has not been denied by any of the authorities. full stop. While the state government in its affidavit has stated that there is no request for any acquisition of the land in question, comma, there is no denial of any nature that compensation has been paid, full stop, para. As held by the Honorable Supreme Court in the case of Vidya Devi, comma, though the right to property is not a fundamental right after the amendment, 44th amendment of the year, 44th amendment of the Constitution in the year 1978, comma, such right can be traced to Article 300A of the Constitution, full stop. In this connection, it may be gainful to rely upon the judgment of Hindustan Petroleum Corporation Limited versus Darius Sapur, Chennai, reported in 2005, 7 SCC 627, and the relevant observations are extracted herein below. Page para 6 of the decision. Okay. In the aforesaid case of Vidya Devi, it has also been laid down that in a welfare state like that of our country, the right to property continues to be a human right and is also a constitutional right under Article 300A, full stop. The position which the petitioner has termed to be illegal of the SSB over the land in question is not in dispute, full stop. The obvious consequence is the aspect of compensation for such illegal possession, full stop. If the land in question is a requirement of permanent nature for the SSB, it has all the avenue to get the same acquired by following the statute holding the field, namely rehabilitation. Full stop. Even otherwise, if the land in question is considered to be required for a temporary period, the requisition amount for the same is also required to be paid to the owners. Full stop. However, from the materials on record, it appears that no action of any nature has been taken either to pay the requisition amount or to pay compensation amount after acquiring the land. Full stop. Para. In view of the aforesaid discussion, this court is of the view that a direction indicated below would serve the ends of justice. Para. It is accordingly directed that an exercise be made by the SSB. This court has also noted that the version of one wing of the government, namely the respond numbers 1 to 5, is different from the other wing of the government, which is respond number 6 to 7. It is a settled principle of law that the government can speak in only one voice, and in this regard, one may gainfully refer to the case of ... wherein the following observations were made. Direction. The SSB to make an exercise, to take a decision, to take a conscious decision regarding the nature of the possession, and if the said land is required for a permanent purpose, immediate requisition be made to the district administration for initiating an acquisition process in accordance with law. In the event the SSB is of the opinion that such position may not be of permanent nature, then then an exercise is required to be made by the district administration for ascertaining the rental value for the land in question for the period under which the SSB is in possession, and thereafter to pay, and thereafter the said rent be paid to the petitioners without any delay. Full stop. It is also made clear that in the event the first option is opted to acquire the land, the requisition amount from the date on which the possession of the land was taken till the date when the land is acquired has to be paid to the petitioners in accordance with law. It is needless to state that so far as that this court has not expressed any opinion on the amount of the quantum which is to be determined by the appropriate authority in accordance with the statute holding the field, and any persons aggrieved would have the right to approach the authority under the act against such determination. With the aforesaid exercise of determining the nature of the requirement of possession by the SSB be done within a period of 1 month from today, and thereafter consequential steps be taken in accordance with law. The writ petition accordingly stands allowed. No other respect possible.
Deeply obliged.
My lord, sorry for interruption.
Yes.
My lord, I'm made to understand that item number 21 to 25 will be taken up, which will take considerable time. My lord, it's this between me and Mr. Daloy. So he'll be going back to Guwahati tomorrow. So if that
You don't want to host him for
No.
tonight.
I would have loved to. But therefore, my lord, may I
He
pray
is
that
not
this
interested.
30 and 31 may be taken up, because my lord, your lordship has extensively covered my case also. And directions also will be more, if I succeed, will be the same. Only I have to show
Which matters?
30 and 31.
No, Mr. Doloy's matter,
Same matter, my lord. This is the same one.
30 and 31.
Yes. This also same, not properly acquired, not as per law.
But the facts we need to
Yes, my lord.
be thorough with the facts.
Facts is very simple.
Your Lordship,
My lord, I have
sorry to
prepared one little.
Yes, yeah.
Your Lordship, by order dated 19/12/24, Your Lordship, the learned AG was asked to appear, assist this court in these two matters. 12/24, Your Lordship.
Okay.
So he has prayed for adjournment of this case today, Your Lordship.
But the requirement of AG may not be required because they have already filed affidavit, 2 affidavit and written instructions, and then RTI reply also. My lord. The only question is whether land acquisition was carried out as per law or not.
If AG wants to appear, we'll accommodate him. It will not look good. First day they are making a request. Any day you say? Same matter.
Same matter.
Yes, Your Lordship.
When will be the AG be available?
He has prayed for Your Lordship 16th of June, Your Lordship.
16 June.
Yes, Your Lordship.
This court is here for 2
No, my lord.
weeks. Try to do it in these 2 weeks.
My lord, in that case, if it is not taken up today, may I pray that this may be taken up on 22nd, because I have discussed with this Mr. Doloy also.
22nd of what?
22nd of this month.
May. 22nd of
Wednesday.
Otherwise, Your Lordship,
Your lordship will be here till that week.
23rd we are leaving.
Your Lordship,
22nd
19.
we may try, but we don't.
Yes,
Court
my
does
lord.
not have any issue problem. It's up to the council.
Your Lordship,
You're-
19,
Huh?
19 of this month.
19, Monday,
Learned AG will be here on
19?
19, Your Lordship.
19, Mr. Dolo. You can join online also, no, not an issue.
Because this letter involved, supposedly it's 400 by the.
400, 500? Oh,
Huge amount of land.
no. The
Malad-
finance matters are involved, we have to be very careful.
Yes, my lord.
Acquisition cannot be a windfall.
Yes, my lord.
What you deserve, you'll get.
Yes. Well, now here only we have to see is whether the acquisition was done or not as per law. What the law says. Only that is and what the Supreme Court says. The provisions of law has to be implemented as prescribed.
And that
It-
there is
yes.
no dispute.
There is no dispute. So, my lord, I will demonstrate that.
No, Mr. Dolo is very fair. Whatever he's in law, he'll not say anything else. That we can.
My learned friend is saying, so we have
No,
done it.
opposing is a matter of, you have to oppose on facts, on in law, but if actually if you make out a case,
So, my lord, 19,
19th, okay.
my lord, in the
Though,
hearing,
how it's
my lord,
three-
hearing is the first item.
We'll not say anything, we'll accommodate you, we'll try to accommodate you. How it's 3T Partin, learned counsel for the petitioners. Also heard 3 Y Dolui, learned senior panel counsel for the Union of India, as well as Y Ram,
Yes, Your Lordship.
learned state council. Correct? The state council has however paid for a little accommodation on behalf of the learned AG of the state. Correct? And praise for taking up the matter on 19th of May 2025. Correct? In view of the aforesaid request, list the case is adjourned, will listed on 19th of May.
Obligation.
My lord, I'll submit this the day or.
On that date.
Item number 25, my lord, I am preparing for the private respondent, my lord.
Oh, those matters, yes.
My lord. My lord, in item number 25, I am appearing on behalf of private respondent, my lord. My lord, may I pray that, my lord, this matter may be listed in the next 2 weeks.
25.
My lord.
Connected.
My lord, I was under impression that the state government has not yet filed any affidavit, my lord. But from the record, it seems, my lord, that they have filed affidavit, my lord. And I may be, my lord, allowed to file affidavit on behalf of private respondent.
Yes, what do you say, other counsel?
Your Lordship,
Mr. Dada was ready for argument, we had said.
Your Lordship,
He's not in, my lord.
Your Lordship,
One case you were arguing, which was that case?
My lord, it is,
253 has been referred over, or is it today?
my lord, that is item number 21, my lord. Of course, issues are, my lord, similar, but my lord, in my.
21 is connected, all these cases.
No, my lord, similar, but not that correct, connected, my lord.
My lord, for convenience, it will be better to segregate the items because the facts are different, my lord. Even
Now you tell us, see, convenience of the court is also convenience
since
of the council.
Other,
Which matter is to be segregated, you tell us, we'll segregate it if it is not connected.
to the petitioner, my lord, the counsel for the petitioner, Mr. S. Mao is also not available in the court, my lord, in item number 25, my lord. May I pray that, my lord, this matter may be listed after 2 weeks, my lord.
25.
Yes.
And other matters?
Other matter, my lord, I'm not, my lord.
24, counsel for the respondent is also not available.
24.
24. I am for the second. But then, in other matter, I humbly request that this matter can be segregated.
All segregated, then why it was all taken up together, everything is with, what is this subject matter involved?
My lord, subject matter is appointment of Gaombura, my lord.
Oh, yes, Gaombura. yes,
Gaombura,
sir.
my lord. There are several,
He's saying that there are difficulties because of the stall in appointment. The Keba is also not being able to be held.
there are so many guidelines, my lord.
Some are against termination and some are against appointment, my lord. So it will be.
And my lord, we don't know, my lord, which rules are my lord, prevail. And government is relying upon that.
Government?
Your Lordship, in this matter, I am for private respondent.
No, we want we want the assistance of the government. What do you say? Oh, okay. His role will be a major role.
My lord, exactly, my lord.
If you are saying that which rules are applicable, not very sure, then we need to have the government stand.
So therefore, my lord, in item number 25, my lord, this. will be-
25, can we segregate 25?
Yes, my lord. We'll file affidavit, my lord, in the meantime.
25, in 25, huh? 25. Who is for the petitioner?
Counsel for the petitioner is also not available, my lord. Mr. S. Mao.
Okay,
Maybe.
25, you write
Yes.
25, huh? Sri M. Kato, learned counsel for the private respondent,
My lord.
has prayed for an adjournment.
My lord.
He has also submitted that this writ petition can be segregated with the series. In view of the aforesaid submission, this writ petition stands segregated from the series and be listed after 2 weeks.
My lord.
25, huh? 2 weeks.
Item number, my lord, 22, 23, my lord, also can be segregated, my lord.
22, 23.
In 22, my lord, I am for the respondent, my lord, and 23, I am for the petitioner, my lord. And
22, 23 will be taken up together.
no, this can also be segregated, my lord.
No, segregated from the series, but will taken up together.
Not necessarily, that can segregate from each other. Different in these two also.
Parties are different.
Yes, in facts are also different.
Can we take it up today? No.
Okay, my lord, on my side, I am ready, my lord. On Monday, my lord. We are ready, lordship, I am ready.
Yours is what, 20?
I don't know, 21, lordship.
21 we can have, 21 there is no prayer till now.
Your Lordship, I am for respondent, private respondent for 4 and 5 in item number 21.
Oh, you're,
Yes, Lordship. Lordship, as a leading counsel having a personal difficulty.
who is the leading counsel?
Dilaji,
Dilaji.
Your Lordship.
What is
So
yes,
the matter may be postponed for tomorrow, Your Lordship. As he's having a difficult person, he could not able to appear.
Tomorrow? Dada? Okay. 21, huh? 21. The learned counsel for the parties have submitted that this matter can be segregated from the series and can be taken up tomorrow. 21 only.
Lordship, in item number
No,
20, WPC 147 is different. That can be taken up today. Learned senior RSI is also present, Lordship.
Not, we are passing order in 21.
21, sir, Lordship, this is different, like 147, WPC 147 is the petitioner.
What is 21? 21 is
Which Lordship?
In item 21, madam, there are two writ petitions, madam.
okay.
Whether 253, madam.
Oh, we take up 253 tomorrow.
Yes, Lord.
You write it 253, yeah. 21. That document has submitted what?
147.
What did you say?
Yeah.
And we'll
No,
take it up
correct.
tomorrow. Accordingly, place this case for consideration tomorrow. This will be only in IA 191 of 2022 and 253 of 2021, WBC. Madam, you have the cause list? Okay. And what about 147?
147, madam, I am preparing
Taken
for,
up today, if my seniors.
madam, let it be, madam. If we-
147 today?
Madam.
And what about your matters?
Lordship, 22 and 23, my lord, it may be taken on Monday, then
Next Monday, 21 and 22, 22 and 23, yeah?
22 and 23.
As requested by the learned counsel for the parties. These two matters stand segregated from the series and be listed for consideration on Monday. Date, huh? Date, what is date? Date is 19th. Okay, 19th. We'll take up this.
I'm for item number 24, Lord.
24, yes.
Yes, Your Lordship, counsel for the respondent is also absent, Lordship.
24.
Yes, this matter may also be segregated. Item number 24, Lord.
But if these are concerning Gaumura, why are you segregating all items?
The entire matter will be heard together.
We'll have this on Monday.
Monday.
Item number 24. On request, list on Monday.
Lordship, item number 147, Lordship.
Yes.
Just for tomorrow it has been fixed, but we have consented.
No, to the 147 we are taking today.
No, for today, Lordship, we have just consented, Lordship. It may be taken up with 20, Lordship.
2-0.
2-0.
Yes,
No issue, Lordship.
147, huh? This is one for right in 147. The learned counsel for the parties are in agreement that this matter be segregated from the series and another date may be fixed. Full stop. Para, as requested, please on 2-0.
2-0.
These matters are clubbed together because of, my lord, there are two, my lord, guidelines, my lord, for appointment of the governors, my lord. It has to be clarified by the state government, my lord. In a given case, sometimes one guideline is produced. In another given case, another guideline was produced, my lord.
Okay, Mr.
That we have already filed affidavit. also.
Tapan will assist us.
We have clarified that.
कौन सा केस में clarified?
Tadung Data.
Huh?
Tadung Data.
Nombura. This, who has provided this? Nombura?
It's me, Lordship.
Have this with you. Okay.
नहीं हम लोग को मंडे 20